అది దగ్గర వేసిందా మళ్ళీ ఎవరు చేశారు పోస్టింగ్ ఎవరు ఒకసారి చెప్పు పార్టీ అడుగుతుంది కదా మళ్ళీ ఇక్కడ మెన్షన్ చేసినట్టున్నా మళ్ళీ అదే అది రేపని ఏమని రాము చెప్పు ఉన్న కంపెనీ మనం ఉండాలి అవి ఉండదు తెలిసేది నువ్వు కూడా కుమారేనా ఫైనాన్స్ item 1 to 13
but the cost surveys is 2000. Who is there for that? GP from Panchayat. Who is there? On
services to you. Standing cost.
next week. Should they inform or have you informed?
I'll inform.
Before meeting only inform. Otherwise, the other day there was objection.
Yeah, for petitioners, madam.
You need to inform other day also.
Yes.
The request of council petition. Post on. Voting by 15 minutes. 15 minutes. 15 minutes.
item 14 to 25
51. I informed other side, madam, kindly 4 weeks. It is promotion matter, madam. Cost surveys, madam.
But I think there was also some implications and contempt of not discussed. Okay.
The counter, it's
Counter I think already there.
not
Not quite.
not the counter only 4 weeks.
Who is Jagannath CH? Services 3, who is services 3?
Informed other side, madam. I informed already.
Okay. 24?
4 weeks.
24
Yes.
24/11.
item 26 to 40
Cost doesn't survive in
The council petitioner. The claim that cause does not survive in the petition seeks permission to withdraw. Accordingly, the petition is dismissed as withdrawn. Industry dismissed. Literature. Next.
Item number 34.
Yes.
Respondent as Balchandra. And to represent Mr. Balchandra. I will inform the appellant.
Last time also there was no representation. Last time also there was no representation. I think there somebody is taking time.
Was slightly displaced. She may have it next week. We have informed the appellant side, appellant counsel also come issue.
You only taken time, but he has only insisted for
Yes. I mean, 10 minutes. We have informed the appellant. She may have it anytime next week.
1611.
No pleasure.
Request of counsel for respondent.
Respondent.
Item 41 to 54. Items 55 to 75.
Sir, my serial number is 73. Am I audible, sir? To check my mic, I am asking, sir. Am I audible?
Yes, tell me.
Am I audible, sir?
Yes, sir, tell me.
Thank you. Nothing, sir.
Yes.
To 95. Item 96 to 105. Item 1D, Balkishan Rao, GP for
Lord, subject to lordship, kind permission, may I make a mention, my lord? I am online.
Yes.
Out of list, I am, Lord, AS 138 of 2007, Lord, it was listed before vacation, and earlier it was, Lord, before other judge. Lord, there is an emergency, it may be taken up next week or tomorrow in the cause list.
Not tomorrow, next week. It's only after Diwali.
Much obliged, my lord.
11.
Some date may be given, my lord. So,
11.
much obliged.
Yes.
Yes, 138 of 2008.
2007, my lord.
2007. 138 of 2007.
Much obliged.
Item 12.
Yes.
Make sure that I inform.
No, read and we'll tell any your colleague. Yes, there was a lot of compliments are given. Take one. Yes.
I'll have next week, item number 1.
Item?
Item number 1, I'll have next week.
Why? Why? Whether it caste survives in this?
Yes, last is Michael Patel's promotion last.
Who is the other side?
This is 2 year election.
This is one only.
This is 2 name.
But the count has not been filed.
And
Only consideration of representation. Promotion. Deputy Registrar.
Yes, last. He is a native of the Medak district last. Dictation was given to the Siddipet district. Due to that, the promotion was not.
Request counter is only first he is seeking a transfer from Tanga relative to detail. Then also because certain matter, why can't we? Who is it? Who is it? Two
services 2.
item 1. What about counter 2017 matter? Only request for transfer from certificates under 1 and another is promotion. After 6 years, whether this will continue or can be accepted. Where is now? What is the present position? Where is he now?
He is in here on the Siddipet.
Siddipet.
Siddipet on the on dictation.
2 weeks. 2 weeks finally. First of 40. Post on 1711. In the meanwhile, responsible file counter passing. Please is added to print the name of GP for services 2.
K. Rama Subbarao, GP for Education Services 1.
Counter already there. Counter is there. Yes. Oh, sir.
Requested password tomorrow election tomorrow for you.
You have a difficulty?
Tomorrow.
That's
Yes.
in this counter required that
Counter already there on record.
is not going to be. Yeah, go on with that.
Without counter.
The teacher is looking at administrative officer. And the Department of Education. There is no channel provided for promotion. Most of administrative officer. Therefore, we had the first respond issued a memo directing the second respond to send a proposal for making amendments. The memo of first respond page number 17.
No, even as per counter also they say that.
They state proposal is pending with the government.
Government.
So they have to consider and pass appropriate orders. That the only thing it can be done in repetition. The themselves admit in the counter.
Madam GP, what do you say?
Para 7 years of my
Madam 9, you just need term.
inspection otherwise.
Pending with the government.
No, you're not sure. It is pending for the government. I have to assert inspection.
Right. See, 2017 now, 2018 you filed counter almost 5 years now. What is the question?
So earlier
The
also
commissioner also in fact recommended that either channels to be.
Which state has to verify it.
earlier also that they have been.
Even they have stated that as per GOMS number 663 shall be considered on the basis of combined senior. Para 7.
There are two aspects. One is that state candidate, another is I think this is the district administrative office. There is no, in fact, they are not being considered. That's what you are saying. Only the only they are in fact the candidates are being considered for promotion.
Unnecessary.
So they are all.
Earlier, about before that, another letter date that they have taken time for getting instruction to ascertain the bidding status. But even now, the same thing is being reported to the on the spot.
Then day after tomorrow, it's the election. I call
Yes. The request of GP for services center. One.
Yes, Sudhir, whom Srinivas.
My lord, I am appearing online, my lord. Lordships be able to hear me?
Yes, still.
Obliged. My lord, this small issue, the petitions before Lordships are, my lord, wife, first petition is wife of Mr. Krupanandam, and 2 and 3 are his children. My lord, there was a family dispute between the first petitioner and her husband.
So
So
have,
they,
have, you
sorry, my
got,
lord,
have you got the counter?
I got the counter.
Just read para 4 of the counter.
Yes.
In fact, amount is already paid to respondent. The
Amounts are paid to the Mr. Krupanandam after the award. Award is given, my lord, on 12/9/2015. Representation is made on 12/2/2016. Legal notice was given on 1/4/2017. And conveniently, they did not mention, my lord, when they released. It's not as if they were released before the award. Award of the Lok Adalat, my lord, as your lordships are aware, is binding on, it's a decree.
but Lokada, the
Lok Adalat, the settlement, my lord, is like a decree, as your lordships are aware.
but the RTC was, in fact, is not party to Lokada. They are not party to the Lokada.
They are not party to the Lok Adalat, but it's a decree. When there is a decree stating, my lord, it's obligatory on the part of the all concerned, my lord, to oblige that.
Only thing that in fact I see that
No, I'll do one thing, my lord. Actually, I understand. Even Krupanandam is not a party. That's what one of the grounds raised. I think I'll implead Krupanandam also, so that, my lord, uh, further steps can be taken. And I also do not know whether they are paid or the settlement was given effective, because after 2017, I think it's
gratuity is paid 1,64,000 paid on 28/2/2011. Well, much prior to that, only other small amounts were paid. The PF was paid on 21/3/2017 and SBT on 25/2 and 10% gratuity on 26/2017. But the gratuity was paid in long back 2011.
my lord. Besides that, I think pension is also there. Pension will be every month.
Yes.
That also, my lord, if your lordships have an award, look at the award.
Which page?
It's at page 20.
$19.
My lord, page 17 is the terms and conditions for compromise.
Yes. So this is not required anything, but to come back to certain benefits and response such as providing.
My lord, may I just suggest one thing subject to your lordship's convenience? May I just say, because I could not, I mean, after the matter is coming now, I tried to contact, but I'm not able to get to it. Lordship, can you give some short time whether they have sorted out, or whether the settlement was given effective by husband? I'm not aware, my lord. It's because it's coming up only recently. So kindly give me some time, my lord. I'll find out, and then if things are sorted out between themselves, my lord, this will become infractions.
What do you say? What do you say?
2018, my lord, there was a direction, my lord, that this honorable court directed the petitioner to include the husband of the petitioner as respondent on 4/1/2018. And this was, my lord,
Yes,
noticed
sir.
on the last occasion.
4/1/2018 there was direction.
5 years elapsed, my lord. This honorable court on last occasion, my lord, has noticed this, and this honorable court wants to dismiss the writ petition on that ground at all, Lord. Apart from that,
It can be dismissed after a week or 10 days. Let me just find out what has happened. And then I think we did not implead. Maybe after that, the things must have been settled. Don't know exactly, my lord. Kindly give me one opportunity. I'll get back and then report to the court.
even after, my lord, kindly see page number 17 for a moment.
Yes.
Not, my lord, the first condition, my lord, the retirement benefits. The
My lord, with respect, my lord, my friend can hold his breath for some time. My lord, for 1 week, your lordship may post it for audits or something next Monday. My lord, I'll come back with lordships can close it.
condition number 1 itself.
Then we'll consider on this.
Yes.
The only what Mr. Sudhir, what is pointing out that this settlement entered between the parties, and in fact RTC, in fact, no way in the picture and there no way concern with the settlement error between the parties. In fact, suppose the Krupanandam supposed to make the payment to the first wife.
Yes.
In fact, the RTC is no way concerned, in fact, no way in the picture. So can't be, that's what he wants to point out.
Yes.
Yes,
No,
sir.
that's true, my lord. Actually, your lordships can close it if I can get to her. Otherwise, your lordships can pass an order in whatever the order it has to be passed. I'm only saying that let there be one opportunity, my lord. I'll just find out and get back to you, so that I will feel guilty that I did not talk to them before the disposal.
1611,
Yes, whichever, any date after 1 week, my lord.
1611 is fine.
Oblige. Your lords may post it for orders on 1611 or for judgment, whichever it is, so that it will be over on that day.
But partly and you said will include the Krupanandam, but then again if you post for order, then again I'll only say that the request I'll post on 1611.
All right. Oblige. What's up?
And further steps.
1611 would be.
Further restrictions and is taking further steps. So taking further steps.
1611 would be Monday, Thursday. All right. All right. Oblige. Deeply obliged.
Sorry. Ravi Kumar, Shri Uma Devi.
I'm online, my lord. I need to file a reply, my lord. Because I received a counter recently from the court. I have taken photocopy and taken the printout. This may be taken next week so that I'll argue the matter. I'll file reply, my lord. Reply is ready now.
In fact, it appears on 25.
I have taken a copy from the court, my lord, as screenshots, and I prepared that reply also. Because reply I could not file it because of lack of time and
2111.
2111. Yes, my lord. Deeply obvious.
Filing reply.
Deeply obvious.
Point in this case is, they include the name of the petitioner in the service register and the nominee in suspension papers. Earlier, the suit was filed without legal relationship with them. Her maintenance case was filed when she was deserted. There is an order in that saying that pension has to be paid. Filed a counter in that at page 15 may take the.
What about notice to
other response.
Third response.
third respondents?
Yes.
Whatever third notice is third respondent.
Track consignment is a worship of business made. But it is delivered.
Service.
Not
Yes,
even last occasion.
It is 2017. You show the third.
Last occasion, you know, it was track consignment shows it is delivered. But even last occasion, none appealed and even today.
Didn't get copy 84.
Yeah.
17. One more picture.
Because counter clearly cannot play fraud with the court's method. Lower court he has agreed. Counter shows at page 15 it starts below. In maintenance case where he filed. Relevant at page 19 may take your para 7. Page 19.
Yes.
Maintenance case for enhancement was filed. he filed a counter stating that it is denied that the respondent got married another woman and neglected and refused to maintain the petition. And now in the nominee melody in pension papers at page 21, instead of petitioner hearing, one lady Bharati Devi is included. Wife is Rameshwaram. Legally wedded wife is Rameshwaram. And their daughters below Sharada and Nami.
You not filed, have you filed counter or?
Correct.
Correct, you want to file counter?
Dispute is between two wives, that is the main problem, that's why I want that.
No, what is state, present status are, amounts are still, the pension is being paid to whom?
Then
Yes,
the instructions on what basis we have served a notice stating that this is
Right.
order, he has accepted and he cannot include Bharati Devi to replace the name. So that they come, now he is receiving pension.
Correct. The employee, he has in fact include or nominated some particular name.
Not include any person when they legally wedded.
Cleared, how will know? How the government will know they will legally wedded or
So
not?
they filed counter into the court, saying that she has not married.
Who has
Basis,
filed counter? Who has filed counter?
we filed suit, my lord, for
We filed, but in the suit, the government is not party.
respondent number 3, that's the reason.
Number 3 is
respondent-
not there before the court. He is served, but he is not appealing before the court. So what you want the government to do?
Can stop, my lord, the participation also.
The government,
Future conduct.
they have very, very limited post.
I accept.
Because ultimately it's the employee who has to give his the nominee name, whom it has to pay.
Last 2 occasions, my lord, time was granted to serve notice again, and we have sent a fresh notice.
Doesn't want to appear before the court in spite of service. At the most we can only stop it.
Because poor lady, she cannot move from pillar to post there.
Correct.
She earlier twice approved and gave a notice also to include. They can call my lord unofficial respondent and set in the hearing. Because pension rules may take for a moment.
Here is
Pension.
is
550.
and pension.
Revised pension rules.
Here in fact under which provision or which provision will direct the government correspondence to include the name. Is there any scope for even including, removing and deleting and including other name? Show that provision so that they can also just show the rule wherein the existing nominee name can be deleted and another name can be asked.
But he himself has accepted before the court saying that he has not married any other person.
So do some degree from the court only.
That's not the issue of
That's not the court.
When he himself has accepted stating that he has not married.
Counter, but in that's ultimately there is no order from any specific order from any court.
Yes.
No.
In maintenance case, there is an order saying that for enhancement, they have to pay
Investment from
rupees 150. Earlier it was only
150 to it is extended 150 to 250 to wife and then children 75 to 2.
Yes, and it was enhanced to 150 to 250.
Yes.
Itself shows where you counter after filing counter only. It was declared.
See, the issue is now we are saying about pension. This is only with regard to maintenance before the court.
That is only maintenance, but where he accepted
Here,
before the court saying that he is not married to any other person. And now under what authority has implemented. That's the reason, my lord, earlier notices along with the decrees was served upon the official respondents.
you take some instruction what we can do. Or just also show the rule post under which we can direct any to respondents. Also clear the pension rules and also in the meanwhile you verify
Yes.
that what is said is she is legally wedded by as per the
Yes, sir.
the
I will
when
refrain, I
the
will
case
take
before
because-
the family court.
Yes.
Yes, now he deliberately is not appearing before the court, in spite of service notice, to avoid any order. What best we can do that we do.
Rule 8 of pension rules says that future conduct of employee, even though pension is sanctioned, future conduct if it is not can be withheld. May take to that.
No, withheld, but whom to pay, that's the one point.
Who to pay?
It's not with regard to pension. Pension now is alive.
Yeah, like that's the other ben, the retirement benefits already, he retired and still in.
He retired in 2006.
What about retirement benefits, any other benefits we have been given or is taken?
Now he is there, my lord, all benefits will be given to only for nominee for future.
They know any, we have not the. We should not tell any criminal case for bigamy or say what you are saying that illegal.
Unless he appears, my lord, though notice is served as not appearing before the court.
The only problem is the scope is very, very limited here.
Yes, yes.
That's the only
Understand,
problem.
my lord. Then get
2 weeks. 11.
HIGHCOURT 3 GP for municipal and 3 Chandrasekhar Rao, GP for services.
From service, not is the pending inquiry, not is the 11 officers are there. Sitting officers, sittings issued in 2022. The instructions will not be whether they proceed their inquiry or not.
We are taking time long.
Is entitled for promotion to the deputy planning mirror. That's of 5 years. There is an interim direction that consider this case for promotion. Meanwhile, is retired from service period 31/10/2020. After which the matter came for hearing, it took time for getting inspection. Because they have conducted inquiry or released the benefits period as per quick price.
Instructions period is
No, but how long is it? They also, it appears to be very old. Euro 617 says it's only should be 3 months simple and
Yes,
6 months.
257. After lapse of 5 years, they initiated.
Now, how long they can wait? How long is the next week? Humiliate the employee.
Whether they completed inquiry or not.
When the rule clearly says that some specific time has been prescribed.
Given Geo is there.
What is irregularity come? What is
Millard is working with the first aid planning Millard in the 2017. They issued charge memo saying that in
demolish?
2012 you are contrary to your sanction permission. Though a sanction permission after transfer to Millard somewhere else, after 4 months they have started construction. They no work sir.
He was not even in the
Yes.
14. Page 14 of this.
And one more issue, Millard, as per the civil court order, Millard, they have constructed. There is a direction not to interfere the construction. As per that order, Millard, they have not taken any initiated proceedings against the persons Millard who have constructed the building.
File counter. Because no counter is not been filed. Counter is not filed. No instructions. 17 matter. In fact, docket says that since we are almost every week is time. From September onwards, time is being taken by you. Your part? 22 finally. Fine counter will listen. Request. GP for services.
Item 7, AVS Bhujangarao, GP for school assistant B. Durga Nageshwarrao.
But I'm appearing through online. But this is a case, my lord, seeking time scale attached to the post. But the party is not in touch with me. Please kindly issue a notice to the party, my lord.
No,
I'm trying to contact him, but he is not coming in.
you issue notice or what is just report? Why? What should give notice to the function? To take steps, you to notice the party and basing on which you can file a memo saying that instructions are not. After
Yes.
that, please.
In spite of that, my lord, as there is an interim order is there, my lord.
Same order, in fact, appears to be
Interim order is there, but that interim order also they implemented to the some extent. I heard. Counter is also not there.
Petitioner reported
they say
3 years internship, they are challenging to show cause notice.
Counter is also not there, my lord. Counter is also not filed.
you also take steps. But direction is given to whom? The respondent, in fact, what this counter has been filed, I think. Counter is filed, no?
Vacate stay, I think vacate filed, my lord, but the counter is not yet filed.
It's the along with not only what they say that if the respondent is now in fact is not disbursing officer, it has to be only regional education.
Third response.
Third respondent is supposed to the direction given to the fifth respondent can't be even implemented because he's not drawing authority.
Corresponding, not related college.
He's only aided college. He doesn't really the direction ought to have been third respondent, second and third respondent.
In this case, drawing and disbursing officer is only the correspondent, my lord.
They, in fact, what they say that they have
May I have it on after 10 days, my lord. I'll ascertain the facts whether this interim order was implemented or not.
Review has been filed. In fact, review has been filed.
A review has been filed, but counter has not been filed.
Review petition has been filed by the respondent. But, they are not very concerned. They do not have any authority or able to come.
To some extent, my lord, to some extent, this order was implemented. Some amounts were already paid to my client. To that extent, I have a knowledge that.
You are saying that
Nowadays, he is not in touch with me.
saying your client is not in touch with you, and then you are saying which is correct.
Yes, but I'll ascertain, my lord. I'm sorry, my lord. I'll get back after 10 days, my lord.
Meanwhile, you also verify. And if you want file counter because the interim direction already there on 50 respond. Then he also filed review petition saying that it has to be only third and fourth respond who has to implement down. If fifth respond is only aided college, they can't.
Yes.
10 days.
At what date, my lord? It's posted?
21/11.
Deep levels. Deep levels.
Also, if you want to file count, you also file count, or you take on further instruction. But what about interim directions, which are impacted? Almost, I think 2017, 18, some interim direction was given.
Yes. Deep levels.
Item 9, A.K. Jayaprakash Rao, 2
21. The council petitioner shall ascertain the present status with regard to complaints of directions of interim order. GP government period.
Your Lordship. You cannot hear your Lordship.
Not there.
We are facing the same.
Right.
That's your. Yeah.
And for the petitioner, 15 weeks time.
The cost survives.
Yes, ma'am. That the employees who are promoted, who are sanctioned, increments of 12 service and 20. Thereafter, they were promoted. They say, since you are promoted, we will recover the sanction amount.
Initially, I think they were given special allowance or non, since they could not promote the petitioners.
But they did not serve any notice, madam, for recovery of the
No,
amount.
but in the proceeding promotion process itself, I think it says that they will recover. They have taken. We also, in fact, somewhere in the petition also it was stated that they have taken undertaking from them. You can't benefit either. One you need to forego. Either you need to get special allowance or you need to get only the benefit of promotion. You can't have both. And the special allowance is more than the promotion. What
They
you
are promoted retrospectively.
that's
Now
something.
we are not eligible.
Retrospectively promoted, and then those amounts are promotion benefits also in fact given to your petitioners.
They want to recover the amounts.
Because you are already paid special allowance. Since at that time there was a delay in effective promotion, they have given special allowance. Because they also counter also very clearly saying that who is appealing for this? That's what he was trying to do. Okay. $21.11. In the meanwhile, you also
Yes.
Counter also will clearly say because they can't have. See, in fact, since there was some administrative, you are saying that because some administrative reasons, their promotions were not effective for a long time. Therefore, the who are in fact in line for promotion, they are given some allowance. In fact, that appears to be more than the promotion.
Yes.
So they can't have both in the request of council to find respondents. Post 21.
Item 10 CH Venkatraman, GP for services, G. Ramarao.
Have to verify, check whether the.
I think
Because the departmental proceedings are pending against him, he is seeking promotion for that. The reference of departmental proceedings. In instruction.
what are any for this? What is the latest status? Who is for the GP 4?
This also we cannot have the instructions. No. Not high.
You don't. There is no counter, no instructions.
I thought,
You only saying that it will be promoted
without reference of department.
without referring to the proceedings, and the proceedings are pending since very long time. Will not be finalized.
Kindly post next week last, I will get a myself to get instruction.
It only appears to be some land dispute with the family members and basing on this thing. Quite common.
2 weeks.
2 weeks finally. Wait instruction retentions or file counter. What's why these department proceedings are pending very long time, even 5 years, 7 years. Request of Modi Council, post on 2211.
Item 11, Rahul I. M. Ram Gopal Rao.
This is maintenance, not. So you are saying about referring to rule of file limited AP. Also say that Telangana government has new rules to 6, as per which the we are looking for response. Count already filed. It appears from the count, it appears that request itself is not maintained. Request of concept of count of file. See, you are saying that as per rule 7 of file EP commission, you wanted the left out post to be given to the next best candidate. Count has been filed saying that rule 7 doesn't apply now, no more in the rules. Now the new rules are being framed as per the Telangana Consultation Commission, as per which, as per rule 6. Any elector post can be given the next notification.
There are 17 matters, 2011 notification issued by the composite state of Andhra Pradesh, then public service commission. Now you made Telangana as a party respondent, which we don't have any record. As per the Reorganization Act, my lord, as per the MOUs, the entire record will be lying with the ATPSC only, insofar as the old recruitment is concerned. This TSPSC has no role at all.
What they relying upon rule 7 of file United AP.
Let them make, my lord, let them withdraw or close this expedition, let them make the appropriate party who the records are lying. So what is the kindly process, my lord? Only Telangana Public Service Commission. Sole respondent, how you are concerned.
You also taken difference saying that that we didn't say. You say that as per new rules of Telangana, the leftover post will be notified in the next GR notification only.
Yes.
That's what the
subsequent another group 1 also held. And recently another group 1 is also under process.
1511 finally.
My argument with permission so far TSPS is concerned, this is our stand.
But your counter doesn't say about your counter is in fact different. Just go to your counter. Your counter says different. Doesn't say that it's not maintainable.
Because we want any vacancies are left over, this case has to be considered.
In the leftover, suppose say some candidates have not joined.
That is rule 68.
68.
Rule 668.
They are relying upon rule 7A of S12 unit AP rule. So that rule in fact not there in the present
this thing.
Which says that any leftover after before sending final list for the appointment, they have to also see that any non-joinings are there. Those have to also be considered. And maybe the next best candidate can be considered. That's what the rule 7 says. But rule 6 says that it has to be only for next notification. That's what in fact you say, but you have not taken the difference saying that non-maintainable or anything.
Of the record I can say. I mean, if the record I can submit that.
You want to file, you file.
I'll produce that memo issued by the MOU memo, my lord. I place it before Lordship's, my lord.
Please. A request of council.
Wednesday or Thursday, it can be thrashed away, my lord, why this old case is pending?
Only Danish.
This matter morning, standing council.
He made a mistake, he wanted
It's going to be after 17.
17, he wanted some time. Counter already filed. You have the copy of counter? Eleven. Request to G.
It's not. If you have 20 students, they write the application.
seeking to refer the document to that to the expert, that at least the being taken by the expert. Against which he suggests we are.
In the stage of judgment. This is filed at the stage of judgment. What is the belated?
Immediately after completion of the entire evidence of the defendant, it is quoted. The court issued the application with for argument. The elder stage is honorable court granted institution for a limited period and permitted me to take out notice that I sent notices to the respondent. I have not received the acknowledgement that is the last day. So 2 weeks time may be granted that I in the meanwhile appeal. From the beginning, it is in dispute whether the signature is in dispute.
Why you take so much long time? Is only the stage of argument?
After completion of the class examination, in the class examination also, the defendant have denied the signature. Therefore, he waited till the completion of the evidence. Then he filed application immediately after closure of the evidence of the defendant.
Wait, no. What's the date of order? 12/10.
Of order 12/10/2023. Limited time may be extended. Only
73, 17, 11.
Yes.
Thinking about extended till
Item 22 and 23, B. Maheshwar Reddy, Chief Inspector Officer, Assembly Ramarao.
both are same. These are both are same. Why does two? Why does two CRPs?
And connected.
3 is different.
Two CRPs.
Sir, Damodar Reddy. The Reddy CRP.
Why the two CRPs? Both are connected or what?
Connected.
Why the
Connected.
why the two AS? What are
Two
two?
two suits are there in that same signature.
Item 18. Reddy.
Petitioner is working as an assistant commissioner of police. Successful response. Actual respondent is junior to the petitioner. Promoted as actual superintendent of police, non-category. Questioning the appointment as connection as additional superintendent of police. His file. His file.
Counter is there. Counter. Counter is there and request. You not serve copy?
In this counter, not have I served the
No. Where you have bundles, you don't file counter. The counters which are filed, you don't have bundles. Counter, just take counter. Counter is always filed.
Take up the copy.
Insurance. It's filed at 19/2018.
It's not sold up. It's paid in the control.
PM Reddy signature is already has endorsement. So one more copy. You don't have copy. Bundle. You don't have bundle. Request. You want to file any reply or you want?
I'll get inspection whether it got promotion to the next post.
Class service in the awesome.
The
request of
contract defined.
the request of council inspection. Ascertain present status. 2311. 2311. In the meanwhile,
Item 24 or Bala Subramaniam DP for Corporation. Venkatragu Ramu.
okay.
Next slide is different. This is more for the outer semester.
Become infectious.
Yes, the seeking promotion pending criminal proceeding. No, it's ended in hospital.
Promotion. Council Krishna. Represent that. Four 0735.
This is 24.
22, 23. 22, 20 different. 22 different, 23 different. 22 for two ladies. Also, Krishna depend that withdraw is
Item 28.
28. Next. Yes.
Item 24 R Bala Subramaniam DP for Corporation. Venkatragu Ramu.
Question Millard challenging the insurance proceeding. Page number 14. For insurance for page number 7/2017 issued by the fifth respondent, and also not paying the pay fixation amount as per the proceedings of 2010 million, that is the page number 21 million.
What is
This Millard government has already filed counter.
Last occasion I filed counter.
Yes.
I was unable to file the enclosures with regard to the suspension proceedings and all those things. Very shortly we will give you motion. And here we have except 16 and 19. Any other day.
Millard, once the counter filed by the government, Millard, why these proceedings are issued, Millard, the eligible person has demoted as a salesman. For the benefit of the fifth respondent, Millard, even now the serial number 17 person is the business manager, but still the petitioner is in the same category. And his 2010 also the payment was not so far as not fixed to him, Millard, even as per the order.
The anyway count is already there.
Counter already there.
So you want only the documents to be filed. Let him file. We can close it.
1 week may be posted next week.
Except 16 and 19, because I am having marriages
17, 11.
17.
Fine. We want next week. 21.
Except 16, 19.
21, 11. Different.
Tell them directly office prior to filing. On the same day.
You can go through and get it. Suppose if serve on the morning, then again he has to record and then at the request of council for the starting.
First.
21, 11.
Item 25 D Lingaram GP for Social Welfare Services 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1.
Correspondence. Who is the correspondent?
GP for social welfare services one.
Services 5 years. Services 5.
Okay, also no. No representation for the petitioner. Is to directed to in the legal.
Vasanta right GP for revenue services.
Yes, I'm the pastor. Counter repair. She'll find counter repair.
Post next week.
Which one?
Request ID. Notice not.
He is also releasing it. No problem. What is it? Complete solution is no rule. Any what is status? Present status. Whether it is promoted, you also know. You also have to take check of the client. You can also tell whether promoted or not. You are there. Verify your with the question. Is there any? You want to file counter or want to argue?
If interim order is there.
Interim order is there. Interim order says
Then he has been promoted or
30th 11/2000 there was interim order saying that if there is no rule prohibiting him from promoting despite pendants of criminal cases,
I'm getting such.
it has to be.
I will have 1 week here also. We will not get it.
The mere pendants of criminal cases doesn't in fact bar them from promotion. 17/11. 17/11.
5 years also.
17/11.
Yes.
Council for the request of both parties. We also verify from your opponent. Next.
Item 27 P Raghavendra Reddy GP for municipal administration. General Taker of
Of the GHL children that will
Who is the respondent? Who is the respondent?
go to further. To implement the revised pay scale for 2015, they are regularized in the
What you 2017 matter. Till you are letting fiction.
Page 11 is the view, regularizing the service administration.
But whatever any further developments after filing your request.
Yes, they have to.
Yeah, there is only saying time just a thought. Come. Request of GP for response. Yes. Can you Meanwhile, the response for account taken.
Item 29, Avinash Desai, GP for Considered Services 2.
I appeal the petition.
Yeah.
Petition, my lords, directed us to seek instructions regarding the cause. My lords, there's a difficulty in contacting the petitioners. I request my lords for an accommodation. We'll report, we'll seek instructions from our client and report to my lords.
How much time you require?
My lords may kindly grant us 2 weeks time.
We are asking for response.
I'm the respondent number 4.
4. What about 1 to 2? Panchayat Raj, who is applying for Panchayat Raj?
Services 2.
You are respondent number 4. You are?
Respondent number 4. Contact petition.
Your name is not R. Chand. Name R. Chand. R. Chandrasekhar. T or R?
R.
R. Chandrasekhar. The council for Krishna. Request time.
Item 30, being Narasimha Gaud, GP for Labor, CVS Ganesh.
Why?
You're fine to register to the counter motion and
You are for?
I'm representing.
Count already filed a long back. Please count already filed long back. You want to file a reply after 5 years.
Kindly can prove it first. They're taking the permission.
What is the issue? Council for petitioner request time for filing reply to the counter filed by the respondent.
Item 31, K. Vasavaredi, Gaddam Srinivas.
Count is correct.
Driver.
Yes. Ready?
27.
Also. Yes.
But the petitioner was appointed as driver. The RTC on 26/7/1989.
The services were regularized from 30th October 1989.
It was appointed on
Appointed on 26/7/1989. After 3 months, services were regularized. That is from 30th October 1989.
yeah.
But as the petitioner did not have any date of birth certificate at the time, as per Rule 19, his age was assessed by the medical officer of the RTC as 3/5/1964. 25 years as on the date, which is recorded as 3/5/1964. May
Rule 9 of
3/5/1964.
Rule 9 of which?
Rule 19. I
19 of?
extracted the same in my affidavit. Paragraph 5 of the affidavit, where the person concerned is unable to furnish a satisfactory evidence of age, it should be assessed by the medical officer of the corporation, and the age so assessed or the age as declared by the person, whichever is more, shall be accepted as final, and the employee shall be assumed to have completed the age as on the date of attestation of the medical officer. In this case, he did not have any certificate. His age was assessed by the medical officer, and Lord may kindly see the page 11 of the middle paper.
Yes.
The appointment of petitioner 22/10/1990. Serial number 1 is the petitioner, my lord.
3/5/1964 is the date of
I beg your pardon.
page 11.
Page 11 is the order of appointment. Criminal division.
Serial number 1, Narsai,
B. Narsaiah. His
Date of
date of birth is
3/5/1964. Date of regulation 30/10/1890.
Yes. Then you have to Lord may kindly see page 13.
Yes.
This is the letter issued by the personal officer of RTC Karimnagar to the medical officer. In this document also his date of birth was clearly mentioned as 3/5/1964.
Yes.
Then you Lord may kindly see the pay slips, page 15. These are two pay slips, page 15 and 53.
Here also it is this.
3/5/64. In both the documents.
Yes.
Then in the page 17 also pay slips issued by the RTC. Page date of birth of the petitioner was declared as described as 3/5/1964.
Yes.
And page 19 also pay slips where it said by date of birth of the. Then we will in April 2014. His date of birth was modified. Page 21, you lost my kindly see. Page 21. The proposal.
Yes.
Page 21. The proposal received from DM Kurkla Depot with the recommendations of ED Karimnagar Zone by reference cited has been examined in detail. In terms of provisions of 19(2) APSRTC employees regulation, VC and MD had accorded permission to alter the date of birth of the so-and-so as 19/4/1959 instead of 3/5/64.
What is the basis for this?
No basis.
But it's only
The document impugned order doesn't say anything about it. Then I requested the authority, page 22 under RTA Act, on what basis you have changed my date of birth? Is the application submitted by the petitioner, page 22, my lord. Yes.
yes.
In reply to this page 22, that these documents were furnished to me, page 27, rounding of 3596 1964 as 19/4/1959. Thereby he is deprived of his 5 years of service. Then page 26, you ought to kindly see.
Here also, what is the basic? Here also nothing in
Page.
People also doesn't say anything. What
It doesn't say. Later on they give clarification, you know.
Yes.
Page 26 it also doesn't say why. In terms of the letter cited, PO informed that in terms of the provisions of regulation 19(2)(b) of APSRTC service regulations 1964, MD has accorded permission to alter the date of birth. Then again he has submitted a representation at page 28. At page 28.
No, but if you just read page 20, no, page 26.
They never, in the counter affidavit, what they say, Lord. As per driving license, had it been taken as so and so, my date of birth should be like that. Lord, may kindly see what they, and the impugned order doesn't say anything. Whereas in the counter affidavit,
Notification also doesn't say. Just come back to page 26. They refer to one letter 11/2004. That is the same thing, which is in fact referred to it.
I find it level similar at page 21.
The same, that is the same thing. It also doesn't say anything about
There is
this.
no reason.
Only VC and MD has accorded permission, but
That's all.
nothing.
But once my date of birth, my age was assessed, date of birth was assessed by the medical officer at the time of appointment. Regulations say that should be final. The counter affidavit, what they say, audit people has taken objection. Therefore, we have altered.
What is the basis for all? What it says?
They refer to my driving license. What they try to justify their action on the ground that page 7, para 7, I'm sorry, count of para 7. It is submitted that on verification of his driving license, the license was issued by licensing authority of so-and-so state. Generally, this is the reason. Generally, the RTA department issuing driving license to the persons who are attaining the age of 18 years or above only. In this case, if it will be calculated back to 18 years from the issuing this license date so and so minus 18, it will be 27/2/1961. Thus, it is clear that the petitioner was above 18 years as on so and so date. The authorized APSRTC doctors also assessed. There is no justice. At the time of, I have categorically asserted that my age was assessed by the medical officer. Regulation also says that when there is no age proof, doctor has to certify. Regulation also says that such certification should be final. Now they referring to my driving license. They reduce my age by 5 years, Miller. That too, your lordship knows, Miller. These kind of explanations in the counter affidavit without mentioning it in the impugned order are not justifiable.
Just come to para 6. They say that there was some communication given to Krishna. Para 6, just read
para 6 of the counter, Miller.
Yes.
submitted that in the year 2011, VC and MD, 31/3/2011, instructions were issued to collect recording of date of birth of employees in service records and validation of PMS payroll. Accordingly, the regional audit wing audited the date of birth of the above named petitioner and corrected and informed to refer the head office. At that time, a letter dated 1/6/2011 has been issued to the petitioner calling for submission of original Xerox certificate in order to record the correct date of birth as per the instructions, as per the circular instructions, and objections raised by the audit wing. At that time, the petitioner informed that there is no document in support of the date of birth and informed his parents orally informed him that his date of birth is so. Accordingly, the date of birth of the petitioner was fixed as so. There is no. Everything is assumption.
No, they are referring only to the driving license. Where is the driving license? A copy of it has been filed. Have you filed along with counter? So your basis for this only driving license. Without filing driving license, how can you sustain this?
From the blood, yes, for medical examination. Doctors who suggest age 30 years as on appointment.
Where is the document? They have not filed any document.
We have issued notice, but the date of birth correction, the year 2011. They have filed. It's counter case 54. Is to submit date of birth certificate.
Yes.
Case 54 along with
54, just a minute.
your personal report, you observe that the date of birth or education certificate is not available. This regard, you are hereby advised to submit your original date of birth certificate within 3 days from date on which it was issued.
I stated so. I report this document and I use it.
నేను ఏ పాఠశాలలో చదువుకోలేదు కావున నాకు పుట్టిన తేదీ టికెట్ ఏమీ లేదు నేను తెలిసిన వారి వద్ద నుండి ఆ పేరు సంతకం వరకు మాత్రం నేర్చుకున్నాను కావున నా వద్ద ఎలాంటి సర్టిఫికేట్లు పుట్టిన తేదీ విషయమై లేవని తెలియపరుచున్నాను మరియు నాకు తెలిసినంత వరకు నా పుట్టిన తేదీ 3/5/64 అని మా పెద్దల ద్వారా తెలుసుకున్నాను మరియు అదే ఉద్యోగ దరఖాస్తులను తెలిపినాను ఇది నిజం. Subsequent issued office order 34/17/56. Further, in the office notification second B Nasimha is retired from the corporation 34/17 or attaining age of superannuation studies 58 years according to the regulation 6(1) year of request notice. So, page 57 bureaucracy, he has agreed the retirement order, he accepted the order, and also he
had taken retirement benefits amount.
Retirement benefits also. Page 57 on 10/1/17. The last portion. So that నాకు రిజిస్టర్ పోస్ట్ ద్వారా వచ్చిన రిటైర్మెంట్ ఆర్డర్ నేను తీసుకున్నాను మరియు నేను సెటిల్మెంట్ క్లెయిమ్ ఫామ్ పంపించినాను అది క్లెయిమ్ ఫామ్ లోని ముచ్చినది మరియు అది ఇప్పుడు సంతకం చేసి సమర్పిస్తున్నాను కావున నాకు రావాల్సిన రిటైర్మెంట్ డబ్బులు.
No, just read that. Read from the beginning.
నా మనవి ఏమనగా నేను ఈ నర్సరీలో పోలీసుల డిపోలో డ్రైవర్ గా పనిచేస్తూ తేదీ 30/4/2017 నుండి సర్వీస్ రిటైర్ అయినాను. నా రిటైర్మెంట్ ఆర్డర్ కూడా మా ఇంటి అడ్రస్ RPAD లో పంపించగా నేను దాన్ని తీసుకున్నాను. తేదీ 6/4/2017 రోజున డ్యూటీ చేసి నా ఉద్యోగం
ఆరోగ్యం బాగాలేని
కారణంగా చేసిన 34/17 వరకు కొనసాగించిన ఎందుకంటే నా ఆరోగ్యం పడలేదు మరియు ఇంటి నుండి ఎటు కదలలేకుండా అనారోగ్యంగా వెంటనే జరిగింది. నాకు రిజిస్టర్డ్ ఫోన్ ద్వారా వచ్చిన రిటైర్మెంట్ ఆర్డర్ ను నేను తీసుకున్నాను మరియు నా సెటిల్మెంట్ క్లెయిమ్ కూడా.
Last para is in fact going against.
Yes, money.
No, read that last four lines. కావున నాకు రావాల్సిన రిటైర్మెంట్ డబ్బులు అన్ని కూడా నాకు సెటిల్ చేసి ఇవ్వగలను. నా యొక్క రిటైర్మెంట్ నేను అంగీకరిస్తున్నాను. ఇది అగ్రీ దట్
because he is without employment. His family needs finance. Therefore, he has taken this letter. It doesn't mean that my humble submission. His right cannot be taken as cannot be deprived, simply because he received the amount. The regulation is clear. Once the
Clarify if you say that there was some medical exam. Where is that copy? You have filed that copy of medical exam.
Rashma kindly see in my affidavit.
There's a reference cited, case number, reference, case 21. Case 21, reference.
Yes.
6/8/2013 reference, case number so and so. For date 6/8/2013. There is some
Difference is there, but if you read the, even if as per your counter para 5, he himself saying that he was subjected to medical examination and as per which the age was assessed as 30 years.
1989. Right, yeah, medical certificate number 75843, 19/4/1989. Economic date of birth was fixed as 19/4/1989. Hence, his date of birth was taken as 19/4/1959.
Where is this document?
Copy was not available.
It plays that will settle the issue.
When there was no which counter we apply service record.
No, when you are saying the case is that he doesn't have any document. He is illiterate. Only the parents of infant informed that 3.964. At the time of joining, since there are no documents are there, you say subsequently you subject to medical examination. The doctors are certified that he is age of 30 years. Accordingly, you have fixed his age as 1959. After that, we have taken steps to rectify this, modify the that was done.
25 years.
He has taken signature of petitioner in country code also. He agreed to that.
See, the once the medical the certificate is produced, then nothing will be. Because now you can't say that because it doesn't have any, even if you, where is that driving license copy? Even that also 1979. Have you filed? Your record should have. Produce both documents then.
Both documents. 2 weeks time and
Because you don't have documents. You are subject to medical examination. Then just verify. Because once a medical certificate is there, then it's accepted. Then we can't go back. 19.2.
which one is higher? Higher is 31.
Provided you produce the documents.
Yes.
Card. Documents for that. Stand for the response.
I got a copy of
Facing
driving license.
next time.
Item 32, P. Venkateshwar Rao, 2 Srimas. Respondent.
Krishna?
Venkateshwar.
The cost services.
Seeking alternative employment without under the provisions of persons with disabilities and where we not filed a counter affidavit along with the judgment of Honorable Supreme Court, where the Honorable Supreme Court clarified that persons who covers under Section 2I of the Act are alone eligible for employment, where the petitioner does not fall under the Section 2I. Petitioner can my lord, his family members, my lord, they are eligible for employment, not the petitioner. And he can also avail, my lord, the additional monetary benefits in view of his retirement.
Not okay. He was injured, not on duty.
My lord,
He was injured in a road accident.
yes, my lord. Thereafter, my lord, he was subjected to a medical examination. And in the medical examination, my lord, the corporation examined the petitioner and declared him as unfit for the post of all categories.
Mm.
Page 8, my lord. Page 8 of the petition.
What are the other alternate? What are the other alternate? Sometimes any
But
scope for
my counter affidavit, I filed a circular, my lord, page number 45. Page number 45 is the circular, my lord.
yes. Spouse or child?
Not the 46 year old HIC. Is the number one. The post to be offered for the spouse or children under the scheme of conductor basis also. But with the spouse or children.
Subject to
Yes,
supplemental education qualification, age, and other
qualification, age and other requisite qualifications as per RTC employment regulation.
Then what is what about the family members? You have not examined him or any, there is no chance of
May not the challenge in this petition is not declaring him as
imagine
medically unfit. He is seeking alternative employment.
for himself.
Yes. The petitioner is not permissible. The Lord should also kindly consider the judgment passed by considering the Supreme Court judgment, note page number 35. The number of matters for disposed of, Lord.
Okay,
Lord, Justice Ramesh and
where is the council?
Lord. Even Teshwar.
Is regular?
Regular, we do RTC matters.
But council for this petitioner absent.
There are a lot of
Contents and all. 15? Most of 15 level. He has not explored about these family members, spouse or children. That was not explored.
and would have avoided in the year 2016 itself.
Because once a certificate, medical certificate is given, that is unfit for any job. His one leg is amputated.
Yes.
In sitting, there will be any no sitting job. Sitting in the office.
Accommodating number of employees. Next.
Item 33, yes, Satyanarayana, GP for services 1 and 3.
The exhibition of sponsors based on the request of the organization to work as a in one of the respond organization.
Yes.
I was recruited against a vacancy by following the last grade employment rules. It is paid. But unfortunately, even though there was no necessity tending to the government blindly stated that Act 2 is applicable in my case of land. The Act 2 is applicable only in case of backdoor of employment. If a person is employed in NMR basis or backdoor method or any other mode of not a regular employee. In this case of land, a key reading of the blood will also tell you the terms of appointment still closed. Because the query is concerned with the page number 12. The query raised for cancellation of my appointment is concerned, I myself enclose a copy, page number 12 of the requisition.
Yes.
That's got the order. Act 2 of 1994, first grade above, lay down the norms and procedures for regulation of appointment to public services and rationalize of staffing patterns and pay structures. This act prohibited government departments, corporations, universities, and local bodies, etc., from making unauthorized appointments through the backdoor of NMRs, daily wages, or appointments on consultant pay. However, the Act 2 did not put any ban on recruitment into the public services. That the Act 2 is strictly prohibited the method of appointment mentioned above, backdoor, NMRs, daily wage. Unfortunately, the one way for cancellation of appointment, they are acting on me, the Act 2. The entire state is recruitment is only this method. Because of that method, every day there are many cases are filing for payment of minimum wages and granting of increments. There is no direct recruitment. Entire state. The state is running with only those employment. When my case comes for consideration, they are saying Act 2. That's what you see my orders of appointment. Page number 18. They read that. 8. Under Rule 4, Category 3 of the Telangana Last Grade Service Rules 1992, Sri G. Harikumar, ex-serviceman, son of G. Moti Lallet, who has been sponsored by the Jilla Sainik Welfare Officer, Hyderabad, district through reference second cited. That second cited is concerned, sponsored. The first one is requisition from the department. We the respond before your lordship. The respondent himself addressed a letter to the Sainik board to sponsor a suitable ex-serviceman to work as Chowkidar. That is 1 and 2. Then he is hereby appointed as Chowkidar in the office of the controller of legal metropolis. Yes, in the Rashkanisi, existing vacancy in the time scale. Now, in the case of backdoor or NMR or any other mode, there is no such language of recruiting a person by using a language of last grade employment, service rules, existing vacancy against a pay scale. It is a recruitment against a vacancy by the competent authority.
Yes.
The reason we are mentioned for cancellation is very funny in nature. Page number 19. Order. Under Rule 4, Category 3 of the Telangana Last Grade Service Rules, Sri Harikumar so-and-so, who was sponsored, Jilla Hyderabad, was appointed Chowkidar in the office of the controller of legal metropolis, Telangana State, in the existing vacancy, in the time scale of so-and-so, temporary, and the services are liable to be terminated. Immediate report so. The last paragraph. The matter was addressed to the government to reference cited and requested the government to issue ratification order so as to enable this office to submit individual payments and so. The government informed that the ratification is against Act 2. Now, by humble submission before the court is concerned, I will not come under the Act 2. Second one is that there was no necessity of sending my proposal to the government after appointment. Then the initiation is made by the department on their own request. Ultimately, my name was sponsored. It is nothing but spoiling a career of a person by inviting.
Next.
I have not made any application in fraudulent manner. They themselves not requested the authority to sponsor. My name is sponsor. The question of the Act 2 does not arise.
Your case is it doesn't come under Act
Come under
2
Act 2.
of 94.
Yes.
Therefore, you have been terminated
Yes.
wrongly.
Yes. Even when unfortunately, even NMR is appointed, that's good. They will put on notice. They are having appointed with regular vacancy and by following the rules.
No notice is
Straight away they are terminated, they are cancelled appointment. Such action cannot be
2016 now what 2023 6 years.
My submission is the repeat the details. That it is, I cannot blame myself or my client. Once we lost the citizen disorder, it is up to the remaining I will work. Period. Even 1 year or 2 years, 3 years. The service part because of closing of the tribunal, things are good.
Yes, what is it?
Permitted minute based all of this. 12 minute GOMS number 94 minute.
Yes.
Permitted minute is
yes.
First paragraph.
Yes.
In accounts you read the first paragraph is all of the paragraph minute. Permitted minute. The first read about this laid down with norms and proceedings of this declaration of the appointment of the Public Service Commission, regulation of the staffing pattern, pay structure of this. The Act prohibited is the government department, cooperative unit, universities and local bodies and making in other unauthorized appointments through this live tour method, MMR, daily wage appointments, and consolidated pay. However, the Act 2 of 1994 did not put any ban of equipment of public service. The government of Andhra Pradesh issued orders for the reference seconds read above on the producing of this following the scrutinized of the recruitment of the direct recruitment and other forward to recruitment of the recruiting the agency through the finance department. The finance department scrutinized all the recruitment of the best recruitment of the base of bylaws. The basing of the including this need of this justification of this possibility of this respondents to surplus staff is likely the financial burden of this base of these proposals of before this cabinet from the obtain the final orders. Once the competent authority to take a final decision, the finance department issue the necessary requisition of this concerned recruiting agency like Andhra Pradesh Public Service Commission, district selection committee to recruiting the function in the provided. Basing on this finance department, permitted finance GO Millard issued. Even Millard is a last time permitted my counter mill page 37. Is 13.7 Millard is typed copy.
Yes.
Pay and account officers Millard proceed Millard in this. Worship can permitted. Past orders to 25,839 rupees per council. Also may be created to individual bank account of this annexure of this. As per the government orders, not occupying. Is GMS number
275.
Department. So department is office of the every kind of post must necessary sending the requisiting the government finance department before filing of the post. In view of this, it is to requisite clarity of the concern of the finance department obtaining the before the appointing of the new justice. Lordship kindly permitted will case the GO Miller. Any government employee Miller is a requisite. GO 38, page 38 Miller. GMS number 275 Millard dated 14/12/2095.
Yes.
This is given. Current para Millard.
Yes.
Paragraph 2 Millard. It is therefore now felt necessary that all the departments and the offices of every kind of whether this full-time or part-time contingent any other category of must necessarily sending the requisition of the government in the government finance department. The government in this finance department will verifying whether the vacancies of the report category to be filed with for the available surplus manpower, and in the event of the non-availability of the suitable candidate, it will be the responsibility of the government in the finance department to issue a requisition of this Andhra Pradesh Public Service Commission of the relevant recruitment agency, special selection board, or to the district employment exchanges for the sponsoring the candidate of this appointment. In this case, officers letter to district. Such recruitment must be sent for the finance department only after getting his clarification from the finance department, collecting for this suitable candidate and is available of the surplus manpower, shall the district recruitment is capped. The secretary of the government, secretary, Andhra Pradesh Public Service Commission, chairman and so on, so police recruitment and the district committee, AP fire service commission, all the requisition of recruiting board committee department of the government is requisition not accepted in requisition of this vacancy unless it is received from the government for the finance department, all the district employees. His must and should be not is the requisition of this finance government. In this counter itself, lordship can be permitted. Yes. It's stated in this paragraph, last paragraph. Page 27 of the my counter. Yes. First paragraph is fill up the vacancy, Jilla Sainik Welfare Officer, the requisite is the sponsor of the candidate. Sponsor 11 candidates, including the commissioner. The committee constituted for filling up the vacancies for short list of the petitioner for the posting orders for issues of the signs were temporary. Only Millard is a purely temporary and the services were liable to be terminated any time without any notice, without gathering any reasons therefore. This paragraph, next paragraph, is the pay bill was petitioner's pay and account officer claiming the salary. The pay and account officer was objection to rejected the bill stating that the GOMS numbers. So all departments and officers, every kind of is one. Post must necessarily sending the requisition of the government of the finance department before the filling of the post of the after getting concurrence of this finance department to the post can be filled. Therefore, this matter was referred to this government ratification. The petition was appointed is the Act 2 of 1994 is not entitled. This resolution order also issued will not is basing on this finance concurrence is not complete. This 26/4/2017 Miller. Yes. This is the proceedings Miller is the 43 Miller is this 26/4/2017 Miller. The matter was last Miller. The matter was addressed to the government to the Japan Power Stated, requesting the government issue the application orders to the office. Suitable in paying the pay account. The government informed that their application was. Anything on this Millard is a rejection order was issued Millard. Yes. The third cited also Millard, the district officer will 10/1/2017 Millard. So addressed to the chief page 40 Millard. Control of legal metrology Millard. To address to the ex-officio principal secretary, put on some surplus. It's a paragraph. Page 2 Millard is paragraph stated. President objections must and should manage conference of the finance department. As per GOMS number. Page 2, para 2. Para 2 number. Para 2 number informed that for the junior account officer of the office sent to the salary bills was also Harikrishna Chaukidar. Same was written to this pay and account officer. The remarks were clarification whether the concern of the finance departments also obtaining with before the appointing is immediate. In this concurrence of this, it is submitted that during this combined state of Andhra Pradesh, 3 posts for Chaukidars were filled and One through this special employment exchange and PH in the year of 2003, and two was Chaukidar was appointed as a year 2009 and 2010. Jilla Sainik Welfare Officer. The pay bills was admitted in said three cases. The same procedure by the adapted with the case also. In this regard, the office was department contents to this officer, pay and account officer. They were advised to this obtain the ratification orders for the finance department and submitted the same proceedings for salary which therefore the government is requested to issue the ratification orders to your sponsors basing on this pay and account office not deducting this payment as per GMS 120.
Next. Sir.
G1 275. Yes, ma'am.
Number 38 of 10. Para 1.
Yes.
The reason for issues of GO, which is read by the government prosecutor, it has come to the notice of the government that some of the heads of department and offices are sending requisitions to the Andhra Pradesh Public Administration, even though there are no clear vacancies or there are surplus manpower available in the government. This perpetually requisition sent by the department and officers resulting in over planning and essentially the problems of surplus manpower in the government. In spite of restrictions from time to time, that any vacancy to be filled up to Andhra Pradesh Public Commission or through any other recruitment agency or from the employment system, but we made only after taking the clearance from the surplus manpower in the finance department for clean cities and the district construction. The none of observation of the instructions to still continuing in the any cases. The reason for issuing this, the recruitment agencies recruiting the persons except their quota, not against a vacancy. If vacancy is available, not the even our state is concerned. Even when Act 2, the Act 2, I include a copy. These are all pertaining irregular appointment, illegal appointment, and outsourcing. First vacancy page number 12. The reason for imposing a ban on recruitment is concerned. There cannot be any illegal or irregular or outsourcing or contractual basis. But unfortunately, our entire state is running only this business. Let me show the state how many clearly vacancies are filled with the direct recruitment and how many manpower is working on outsourcing and contract.
Yes.
So this case on hand is concerned. The para 1 application, when the authority is filling the vacancy, not against a vacancy. When there was no clear vacancy, if there is excess quota, filling the vacancy, the 275 is applicable. If Chaukidar postponed there was a vacancy, sponsored by the exchange. And cancellation of such appointment under the guise of Act 2.
The appointment was made by the department, not by HPSC. No, this appointment, this the Krishna was appointed by legal matters department.
Yes,
not
legal
by
metrology department. The Chaukidar post is from the their deed establishment.
Correct. Now, if you read that GO 275, it says that whenever any appointments are made or selected through Public Service Commission, then they have to take condition. If it is not done through APPSC,
that is the reason that para 1, the reason for issuing 275 GO is when there was no clear vacancy, a surplus manpower recruitment is made. Yes, it is not surplus, not against a vacancy. It's a vacancy.
And not appointed through APPSC.
The APPSC recruitment.
In fact, it says that any requisition made. If you read first 3-4 lines.
Yes, madam, it has come to the notice.
Yes.
It has come to the notice of government that some of the heads of department and officers are sending requisitions to Andhra Pradesh Public Service Commission, even though there are no clear vacancies or there are surplus manpower available in the government. If you Perfunctory requisitions
Perfunctory
sent to the department and officers is resulting in overmanning and aggravating the problems in surplus manpower in government. In this case, we have twofold. One is the reason mentioned in the cancellation is Act 2. Act 2. The reason when they cannot improve the case by way of filing counter or affirmative. The reason mentioned in the Act 2. The keen reading of the Act 2 is applicable only to the outsourcing, contract, or irregular appointments.
But you just read again you read that para 1.
Which one?
Of the second part. Page 38.
It is therefore now felt responsible.
No, in spite of the instructions from middle.
In spite of instructions from time to time, any vacancy to be filled up through otherwise public information or not through any other recruitment agency or from employment exchange must be made only after taking the clearance from the surplus manpower cell, the finance department for twin cities and the district collectors in the districts. The non-observations of the instructions is still continuing in the many cases. But here the case on hand is concerned, the reason mentioned by cancellation is Act 2.
Yes.
They, by way of counter, the last well aware, by way of counter, they cannot improve their case by mentioning some keyword or executive instructions.
Only we need to see whether the Act 2
Secondary, we have the.
Only we need to say whether Act 2 applies to this appointment or not. You refer to Act 2 of 1994 on the it was terminated. Whether the Act 2 is applicable to the present case, that's the only point what we. Yes. Wait for that. Yes, sir.
Even when the RDR principle is concerned.
No notice has been issued.
Even on that ground also it is liable to go. It is any second proposition of the solution case is concerned. Last government. Appointment of in-service candidate, a constable, a sub-inspector on basis of limited department committee examination, withdrawal of order of appointment of a citizen reported to training institute for basic training on the ground that it did not meet eligibility criteria, there any show-cause notice issued, nor any reasons mentioned in order withdrawing appointment as to what are the eligibility criteria which petitioner did not meet. This will order held violative of principles of ethics. Even in this case, he was given promotion, he reported to duty. Subsequently, they come forward with some cancellation. Those circumstances only on the ground of violation of principles the produce was said. In this case, on hand, the reason mentioned in the impute order is something. My little brother is arguing something by way of counter.
Counter melody is yes.
My basic contention is that they cannot improve their case by way of finding this type of counters.
Right.
Next, page 3 melody act. Page 3 of the act. Should be paragraph. Yes. Rule 3 melody. Rule 3(1) melody is the appointment any person is the public services any post or class category or grade daily wage employees is the prohibited. Second one, no temporary appointment shall be made any public service post the class of category grade without prior permission of the competent authority and without name of this concern and concerned candidate being sponsored by the employment action. In this case, not is the prior permission not is a finance concurrence was must and should.
Right. Okay.
Item 35K Ram Reddy, GP for revenue.
Yeah, but it was urgent for the government to just state something that is private county.
It's a case of compulsory apartment. This was filed in 2013 when before the expired 18. Local administrative schedule. And its closure right is transferred here, it's number now. Case in brief is that when he applied for compulsory appointment,
What do you say?
Progress or
I don't know whether even after 10 long years, notice are not being filed, whether
On 17 matter.
17 is transferred. It is from Andhra Pradesh administrative tribunal.
Even prior to that.
Yes, it is 13 minutes.
10 years.
Yeah. The last
These matters are being transferred.
Then after appoint transfer also there is
Yes, for 5 years
17 now it's 17 6 years have left.
And may drive the lordship's attention to the docket records regarding the docket. How many times it was urgent for their counter? Simple matter, the issue involved in this case is very simple. The father of the petitioner committed suicide and died.
You are referring to some judgment and WP transfer 5946/2000 covered matter.
Yes, covered matter in respect of age is concerned. Because now that he is about 40 years, even for those 50 years old cases, these cases can be considered because it is pending before the some forum or the other. Now it is before the court. That is only required.
Taking time is almost like September onwards is taking time.
One more chance.
Also just see the flight of the petitioner.
All the subject written 2 weeks time. Regarding compassion for.
Yes.
May I make only one submission? The objection for appointment is that the father of the petitioner committed suicide and died. For that they said it is not for people who commit suicide and die. Compassionate appointment is not for them. Go there, the stand. But I have stated that there is no such condition in the original scheme of the compassionate appointment, and even sometime in 2007 there was a clarification. But for cases where people commit suicide, in their cases also where the company appointments can be given. So that also that I have filed, by IA I have filed. There was a condition in the IA that clarification saying that this is only for prospectively available. This condition is prospectively available. That I have filed an IA 1 of 2020, so it's ordered on 27/7/2023.
You also challenge some.
No, that's what clarification will. Clarification is that these compassionate appointments for student cases will be only from prospective effect from 2007 onwards.
What is the GO? Circular memo?
Circular is on page 10.
19/7/2007.
Page 10, you are not see. Paragraph 4, straight away.
Yes.
The order shall come into force with immediate effect prospectively, and the old case shall not be reopened. But this I have challenged. And the paragraph 2 makes it clear for cases of
compassion appointment
committing suicide. The Lord should make it to paragraph 2. And line about 1, 2, 3, 4, 5. A deceased government employee who died by committing suicide while in service would be the same as that of the family of the deceased government employee who died in harness. Treating the same as the same. But having said so, the last paragraph only says it is only from prospective effect. So that I said it's not correct. Because the main scheme of appointment is on page 7. The scheme of appointment, the compulsory appointment.
Only says prospective.
Prospectively is I have challenged that in IA. I have amendment to my earlier mistake. May I also draw one moment to Lord's attention. The other day when it was before the other judgment, I also submitted copy of the judgment 1998 SCS online. In case of Anwar Farooqi.
Yes. Union of India.
Yes. The first paragraph itself says, as per the instructions comprised of recruitment so and so, the employee who died in harness, including death of suicide, shall be considered is the point. Death is death.
Correct, but when circular memo is there, particularly.
Circular memo will have challenge for IA 1 of 2020. The circular memo will the last are aware. It cannot overrule the main scheme.
Have you placed that those not we may where the main scheme?
Scheme is on page 7 minutes. EOMS number 687. This is about a general thing. I saw how the recruitment is to be made, process and procedure. But it's also exempt in fact. Last paragraph on page 8 may also kindly be perused. The government, the further that the regular appointments made on the floor will be kept outside for a honorable Mr. This is also there. What they would now say is, I will only draw your last attention on page 9. What they would say is, if the government employee who commits suicide, you are not eligible. That's what they say. When I clarified all these things in my own email. Yes.
It is stated that suicide is to give
File counter. You
First,
file.
may see the
No.
matter number 2 or 2 by 3 or
No, you want to argue or you want to file counter?
please file count.
Request of counsel for either you
Yes, we file.
a counsel or written instructions finally. It made it clear that no further time will be granted. Please see my to in the name of GP for services to.
Item 36, N. Indrasena Reddy, P. Sriharsha Reddy.
Right. It was hard on 1610. Also made some. Was under the option for orders.
Find the counter. It's the respondent.
Also say that part of amount was already paid. 2,14,274 was already paid towards the activity, and 6,239 towards FDIs. What is the research system?
She has to approach the
Friday, we'll closing time. Friday. And we will you indicate what is the status, we want to continue or the thing that on some statement will not be made. If further cause survives in the matter, the further cause survives in the matter. In the later
nothing
payments
survives,
are made,
terminal benefits have been paid.
already paid.
And for problem from, they have to approach the concerned matter.
Take instructions and we will close it Friday. It's a council question. Taking further instructions with the cause in the question survives.
Item 41.
Partially say.
Item 41, V. Ravi Kumar Reddy, GP for services.
GP taken time for it. Well, subject after suppose sir after argument. Regarding the payment of the required as the secretary, Federal Department. Also now the internally and the actually 58 years. And I have put for employee have to get for the then either 60 years.
Yes.
And they are not observed, they are not paid a scale and they confirm in rate. But they basically we both are simply came up. So they take a time. As a case of
What it says,
George Collington, where is the same. The 13 of the Panchayat Secretary in Nalgonda district, retained university in the age of 60 years. See the year discrimination. 111 to 13 to 13 is 60. Is the Panchayat Secretary post person.
they counter offer to clearly admitted that person, they were not observed to the defense of law. Themselves at the appointment also must be the internal department of the legal players.
Government also filed counter and standing court also filed.
Submitted.
Totally there. It's not so infected. It's hard before too. Last time only has taken time.
We submitted both of them. They said that they are redeployment. They will submit some judgment, but they are not because this is the third time also. Not coming. Submitting the arguments, and we argued before the other three benches after. The benches are going on changing. This is the fate of it. It's not first time. Three benches have been changed after arguments, and eventually, finally, arguments.
Who is in fact, who is services too?
Services, we are services.
We are not aware. Any further arguments to be there or the partially reserved for others?
I have not attended it. This is the first time.
Want to advance? If you want to advance an argument, it's fine. Otherwise, if you don't want anything, then we'll.
I just want to submit one clarification. For our county and also the faculty panel about 5 years.
Yeah.
And the competitive region.
Counter filed by?
Yes, all the first price counter.
No.
We are filing counter on behalf of 1,
3 and 4. 1, 3 and 4.
Yes.
5 years.
Yes.
Submitted that the petitioner was not observed against the department. The petitioner was appointed as franchise secretary. Deployment only on other duties basis on the willingness of human election. The government has issued clarification instructions in memo number 4. Panchayat secretaries appointed on redeployment as per the willingness given will be governed by the service condition prescribed by the Panchayat secretaries at the age of superannuation would be after completion of 15 years. The commissioner holds Hyderabad and district Panchayat officer were therefore requested to take necessary action accordingly. In view of the above, it is not feasible to consider the petitioner in services till he attains the age of superannuation at the age of 60 years. The petitioner has enjoyed the status of Panchayat secretary belong to superior cadre of all these 15 years. Had the petitioner has remained the country in service for the last grade employee, he would have continued in service till he attains the age of superannuation at 60 years. He has been irregular continuing in service option that's sixth para states that. The affidavit is submitted that he was moving to the continued in service till the end of October 2017 and against. So it's obtained the age of superannuation of 58 years. By other side, in fact, no employee can be allowed to remain in service beyond the age of superannuation. Whatsoever the emoluments paid are liable for recover from the individual from the encashment covered, leave encashment, only all half pay and other pension benefits. The service conditions of Panchayat secretaries are applicable in this case. Since the petitioner was appointed Panchayat secretary on redeployment, as per the willingness given and thereby the age of superannuation would be 58 years of age. As per the clarificatory instructions issued by the GMS noise. In these GMS also, only 58 years is eligible allowed. In view of the above, the orders passed by the respondents are not erroneous and does not amount to illegal, arbitrary and consortium to falsely state in the dictatorship. The main carry is at para number 7. If submitted and it is not feasible to consider the petitioner in service till he attains the age of superannuation at 60 years, as Panchayat secretary appointed on redeployment. as the service conditions prescribed for Panchayat secretaries are applicable in those cases who are appointed as Panchayat secretaries on redeployment. As per the willingness given, the age of superannuation of the redeployed employee would be at the age of 58 years. As per the clarification instruction issued by the government of GM as in memo number so and so dated, but whereas the petitioner has falsely approached the High Court of Judication, though the petition is devoid on merits. Your Lordship, kindly see page number 40. Page number 58, Your Lordship. Dated 31/5/2000.
58 of?
See, count the Your Lordship.
It is not there.
38. Page number 38.
Yes.
The application of the Commission of Panchayat and Rural Employment, Hyderabad District Panchayat, Adilabad is invited to the reference cited and he is informed that so and so Deputy Executive Engineer Adilabad District has given willingness to work as Panchayat Secretary. Accordingly, he was appointed as Panchayat Secretary on redeployment basis. Hence, the age of retirement to so and so. Now working as Panchayat Secretary in Nirmal Mandal so and so is 58 as the service conditions of Panchayat Secretary should apply. The Commission of Panchayat Secretary is therefore requested to take necessary action accordingly.
But this
This is
the recommendation letter to declare demand after referring is the city. Not necessarily. Not retired. There is no proof that he has retired on the application of the city. It's not also part of the proceedings of the district collector. The Nalgona 2013, they clearly admitted that taking also given district different views and different for district to district. And see the Election Commission may read it to me.
GP, is there any document that where he has admitted that
here we can see he has been working
it will be only 58 years? Or is the, so the same is applicable to him?
petitioner.
Is only that letters we are internal letters will be 58 years. Whether same is
He has to is age 58 years.
no according to Krishna, he said that he was only on the deputation in other department.
Yes, redeployment.
Redeployment.
He is in the place of other.
The salary that what is the deputation?
They are
Not given promotion.
They were not given promotion.
Promotion. That's
They were not conferred the grade. They were not also paid in case of Panchayat Secretary. They were not observed into the PRN department. Let them observe into the PRN.
It remains with the parent
No,
department.
that's what.
Therefore, the rule, the parent department rule will impact
Rule
applicable
will
to him and it should be 60 years.
Yes, sir. The last quote bill. So I'll use another was the age, the act of you can see.
What do you say about the on this aspect, GP? What do you say on this? He was not either given the applicable salary. One. Secondly, he was not promoted.
Yes.
And he was not, in fact,
But even he was given an opportunity to downgrade him. He was in service as a Panchayat.
he was not paid the salaries as per the redeployment for the subsequent department. And also he was not promoted. Whether these rules apply to him or his only parent department rule has to apply.
They are saying, "Rule I am enjoying the Panchayat Secretary status." What is the status of you can see?
Because he
They
was.
are not conferred any. They are not conferred to grade 3. They are not paying the Panchayat Secretary salary, and they are not observed into the PR department. Now, my humble submission is they should have reverted, departed from the finance department of training at 58 years. They have not done so because they have given a partiality of penalty.
Come to retirement, you apply the redeployment department, but you don't give promotion, you don't pay the salary. For retirement, you apply. For other the promotion and the salary, you don't apply.
Let them from the date of appointment till retirement of 58 years. Let them confer and let them pay the salary of the Panchayat Secretary. Confirm them.
Not for the salaries, Your Lordship. They are paying it. Your Lordship, the kind of thing is paying.
2 years. I am asking for 2 years.
Yes.
2 years retirement.
2 years retirement.
If
but
you
they are not
eventually
for
retired me. If you eventually retired me.
He says that only for superannuation you apply this rule.
That previous.
For pay, appoint the promotion and salary don't pay as per the redeployment department. That's what it. Either you apply all or you don't apply. You can't have you can't apply one and the other two don't apply. It has to apply in total. Or you re-apply to the current
He
department.
must be redeployed only for his age is 15. If he is a permanent employee, his superannuation will be 60 years.
Not permanent employee.
The claim says so.
You are not permanent employee.
In fact,
Redeploy inter department.
Yes.
The Act of Service Vacancy. Section 3 of the vacancy. The Andhra Pradesh law of the employment regulation, the age of prolongation. That's already earlier. Section 3 of vacancy. A separate law vacancy. Every government employee not being a workman belonging to last period service shall refrain from service on the afternoon of the last day of the month in which he attained age of 60 years. Every workman, whether in the superior or last grade service or in any service notified as a retired cell, utterly be retained in service up to the age of 60 years. It clearly says so. The circular notion of the GOs or circulars are prevents over this.
No, this what is circular circular is. It only say 58 years.
50 no. Section 3. Section 3 also can see.
Section 3 only.
Class 2. 3. Every government employee not being a workman and belongs to the last year service, so retired from service on the last year of 60 years. Every workman, whether in superior or last year service or any other service notified as the employer cell, are retained in service up to the age of 60 years.
Yes. You want to add in? Want to add any other? That's fine. What's that?
It's been for 6 respondents.
What is instance? Only file count. Only file counter.
File counter. So this is the
Counter.
now saying they're saying instructions.
Counter is there on just go to your counter if you want to add anything into. You are appealing for?
R6 pillar.
R6 you already file count. You already file counter.
Yes. Copy is not Copy is with me.
If you don't have counter.
Yes, no. So only the instructions given by the district collector. He also the return the after the return 58 years. There is not also the power to tell me. That is the only. What's on we have to work for orders period. What is the orders? The orders.
Tomorrow.
Document for judgment. Otherwise, also
same order. Same caption.
The going on taking time also. This is not first time.
Anyway, they have to tomorrow only 2 days only. You think say what?
Left side of the it was posted the next day. It was changed again. That is my problem. Also, I am facing.
No, but anyway, this 2 days nothing is going to happen.
Tomorrow also, let go. I will give the supply right now.
Okay, tomorrow.
Tomorrow.
Take instruction whatever.
Item 42, Sri Srinivas Baba, duty for services for.
No further argument. They are taking going on taking time.
Yes.
Yeah. Not focus selecting.
Counter not.
Counter is there.
Counter is there.
Yes, I find counter that counter along with exception of it's report directed to keep high court vacated. That's why it finds a exception. Court on 17th.
The request of
petitioner.
Councillor Krishna. Post on 1711 finally.
Item 43, CH Venkatraman, please rehearse Sharidi.
Yes, phasing out the bundle frankly have it next.
You have taken time on 22/9. 610.
And this online version has print the name of services to your lordship and medical is for services to. The services one is for on number 2 your lordship. I'm seeking to release the pensionary benefits.
As per one chairman in CMD category always one. Who is applying for all? Standing council is there, a single in.
Unofficial respondent also have.
No, unofficial is not there. Which is the item?
That R2 is for services 1.
No. Which item you? Item 43. It's a single in column. Here for respondent or where is Mr. Yasin? Finally, next week. No further. So let us start. Answer the question. We will reconstruct the bundle.
Item 45 T quotation of GP for medical and health, GP for services. One within possible speaker.
Is where wife of the deceased is depending on and respond number 3 also claiming that she is the wife of the deceased.
Last occasion you taken time state that there is some settlement.
Settlement between the parties. Petitioner and respondent. Yes.
They are seeking pensionary benefits.
Who is third respondent?
Unofficial response.
Unofficial response, he also claiming that she is the wife of the deceased.
Counter
also filing.
the third respondent they find appearing or anybody is appearing for third respondent? Counters with fight? No counters. Again, this will probably same this will continue. Because what you as per the counter, what they saying that so only when a decrease call, then they will continue. Because service records shows the name of third respondent. there was some understanding entered between the petitioner and the third respondent. They filed only memorandum of understanding. They are not accepting. The department is not accepting that is MOU. They will act only when a decree is passed. And the same is contrary to Rule 50. Notice, sir, third respondent. Third respondent, something. Anybody representing to third respondent?
Answer.
Answer. Because third respondent is not served, answered.
It is 2019 endorsements.
Even that MOU also not filed. Whatever the MOU entered between the petitioner and third respondent also not placed on it.
We will file. There is a any MOU is there, we will file.
Request of also petitioner. Fourth level. In the meanwhile, you also wait for whether the third respondent
Will get in.
you because 2019 there's a notice return answer. Don't take notice.
I will get an instruction from the class petitioner from this.
You won't take notice also, you take otherwise without presence of third respondent, it's difficult for the respondent. Petitioner is permitted to take personal notice on third respondent.
From 45 to 47, R. Prabhakar, S. Satyanarayana Rao.
2311. 2411.
Lord, JP is accepting the pass over. 45, 46, 47, Lord. Current is same. Corrected case. 45, 46, 47, Lord. Counter filed, Lord. Already counter filed. Finally, hearing is pending.
What? Pass over or?
Pass over.
Pass over.
Item 48C, Rajshekar Reddy, JP for Social Welfare, Balkishan Rao.
May please.
Short pass.
Yes, so connected to.
No. Different.
Okay. Also.
Item 49, Vedula Srinivas, JP for Technical Education.
Millards, I appear for the respondent college in this matter, Millards. We have I'm appearing on behalf of Tarunji Reddy, Millards. I filed my wakalat in this matter, Millards. I'm seeking time to get instruction in the matter and file my counter, Millards. There is an interim order that has been passed. Accordingly, I've been informed that the person petitioner was taken back into the college. I need to get detailed instruction and file my counter. I'm seeking time for that. Josh can grant me 2 weeks time.
This time. Sections. Pardon me. 2211.
Obliged.
Second 11.
Obliged.
Section and get ready.
Item 50, Srinivas Rao, M. G. Praveen Kumar, G. Uma Devi, A.S. Vasudevan.
What about Vishnu? Srivastava? You ready? Counter other anything. Counter partner recently. What about the council first? What is the issue? What is the issue in the case? What is the issue?
Petitioners, and petitioners in lordship, sir, they are outsourcing agency and they are filing petition for considering their case, your lordship. What you have to do? If this was terminated, your lordship, and one of the petitioners. What it must be. Placement of 38 in the counter, your lordship, which we have filed. 38 in my counter.
38.
38.
38 is
Earlier counter. It's an additional counter. One of the petitioners have given a letter.
No. This is not on the.
Yes.
US number
Tuesday. Earlier standing.
what's not there.
Second petition was
Only one respondent, only one petitioner.
yes, sir.
What about other questions? Only one of the questions, in fact, he wants to draw. What about others?
Because the next week, you'll have to inform petitioner counsel. Because he has to.
Yes.
And find that.
No documentation for that. For respondents?
Yes, sir.
Both respondents.
Yes, was, yes. Sir. Okay.
Respondents. Next time. The place on record will counter filing by them on behalf of respondents. The place on record is counter is not there.
Yes. Sir.
First. Twenty-four 11.
Item 51 C Ram GP for revenue services to
The case where the petitioner aspirants are rural plant attendant posting and they got selected, they got appointed. After that, the issue of proceedings made at the notice for verification of genuineness or otherwise of a local agency area certificates. As a matter of fact, that all the petitioners they belong to ST reservation candidate category, and STs are two kinds: general ST candidates and other set of people, though they are STs, they used to reside in agency area places. That is the reason why whenever any recruitment notification is issued, a particular quota of vacancies supposed to be meant for recruitment with the local agency area candidates. Local agency area candidates are those who have been residing in agency area since from independence till date. Now, these people, because of their outstanding merits secured in selection process, these people were not selected and appointed under local agency area basis. These people got appointed and selected on the strength of their ST category alone. Now, though they got appointed general vacancies just like any other ST candidate, now they want to testify that genuineness or otherwise of their certificate. Aggrieved by the same millard, this petition is filed, and this point is no longer res integra millard. I may permit to take a last stand. Page number 2 not 3.
Last date actually you have taken time. Complete Telangana State Power Generation Corporation. Have you filed an application?
And petitioner counsel.
You only taken. Only taken time for filing application to implement Telangana State Power Generation Corporation. What was the response here? Revenue.
Madhavi is the standing counsel.
Why it is recorded as State Power Generation Corporation report? 44375 same.
Wait for master. Where report master?
Wrong motion. So it's required because is it correct? You wanted to increase some. Why state gen? Because Telangana State Power Generation Corporation. In fact, is
I will do one thing.
verify whether it is required. What about other GP for revenue or not? Who is appealing for other respondents? No counter.
But in fact, though we are aspirants of unit plant attendant post millard, the notices were issued at the department. That is the reason why millard we did make the Genco a party respondent. The time of filing is pretty.
But that's not it. You have taken and then verify whether you want to implement or not. Who is
I will
applying
do one
for-
thing will like that. To avoid the further complications, we do that. Kindly grant 2 weeks time, relax, please wait.
Also, professional takes time. It takes steps to implement Telangana State Providential Card. Who is applying for us? Nobody is there. GP for GP 2 or 1 who is services 2. Services 2. Wait, in fact, this was revenue department, the RDO is there.
GP for services too.
Who is there?
GP for revenue and GP for service.
Item 52, C. Yadagiri, GP for Higher Education, M. Murali Krishna, Kishore Ropi.
Nobody there.
No. C. Yadagiri.
Last time you returned that you have given a local. Then okay. Postal 1511.
Item 53, R.V. Mallikarjun Rao, L. Dayakar Reddy, GP for Services, T. Chandrasekhar Rao.
Postal.
Item 54, D. Balkishan Rao, GP for Revenue.
May please.
Yes.
Appearing on online. Lastly, the matter pertaining to punishment, imposing the punishment of 5% pension cut for 5 years.
Yeah.
Improving proceedings, minute page number 7. Question counter also filed by the respondents.
Counter also filed.
Yes, my lord. Two grounds may raised in the writ petition.
Who is applying for response?
Services 2, I think so much.
So only shows GP for revenue, but services to this is not printed.
May can you take up next week, Murad, or any available date?
Next week we go to only third week. Post and 2911 I posted. Request of council question, post and 2911. This is directed in the name GP for services 2.
Yes, madam.
आइए नंबर दो भिजाई थी यार सेम है बोलते आइए नंबर 123 है 185 तक है समझे आप हाँ अब इसमें क्या है बोले तो जी हाँ दो में क्या है 170 सेम है ना एडवोकेट को बुला के ये दोनों वो क्या बोलते हैं डॉक्टर को से दिखाना पड़ता है हाँ कहीं पे नहीं अरे क्या ना दो है ना 1/2023 में भी ज्यादा सुना ये दो निकल जाते हैं इधर से 179 180 सेक्शन तो फिर आइटम को इसमें भी एड्रेस चेंज करो इसमें फिर दो एप्लीकेशन डाले अब जो आप जो बोल रहे हैं फिर आप मैडम ऑर्डर दिए बाद ना लेटेस्ट अपना नंबर है ना और इसमें भी प्रिंट होना अपना बेंच पे भी ऑर्डर किए मैडम अपन नहीं कर सकते
कुमार
नहीं
ఐటమ్ 23 తీసేవా డిస్పోజ్ ఆఫ్ ఆయన దగ్గర
या फिर रजिस्ट्री करा
ఎవరు తన ఎస్కేజే
इसमें प्रिंट हुआ फिर मैडम भी
డిస్పోజ్ ఆఫ్
ऑर्डर
ఈ రోజు డిస్మిస్ గా
ఆఫీస్ బాయ్
డిస్మిస్ గా విత్డ్రాన్ ఉంటుండడు 38099 380 या मूड नहीं
इसके बाद नॉट प्रेस आइए तो नहीं कर सकते अपन नॉट प्रेस बोल के हम कर दिए तो हम प्रिंट नहीं होना फिर मैडम ऑर्डर नहीं करना रजिस्ट्री का कॉल आता है ना तो वो नॉट प्रेस आप लिख के चले आते हैं कल के दिन आप
हेलो చెప్పండి
इनको बुला के 179 180 खाली अपन भेज देता हूँ सेक्शन में मैं आपको आके समझाता हूँ आप एड्रेस सही है वो रहे ना उसका लेटेस्ट वही है ना
నా సెల్ నుంచి మాట్లాడుతున్నా వినిపిస్తున్నది
हाँ 19 में सही हुआ ना ये 23
వాయిస్ వినపడలేదు ఎంతో చెప్తుంది
32 उसके के बाद हम एज निकले 30 उनको बुला के आइए
మీరు చూసుకోవాలి మామూలుగా
మనం మీరే చూసుకోవాలి. కంప్యూటర్లో మీ హోంవర్క్ ఉందండి.
అడ్వకేట్ అంటే బాగుంది బాగుంది చూసుకోవాలి
ఎక్కడి నుంచి అనాలా? ఆ సెల్ నుంచి అనాలి, ఎక్కడి నుంచి అనాలా? అవును అక్కడే ఆయన ఎంతో మంచిది ఈయన పెట్టేస్తాక ఎక్కడ పోవాలా? జడ్జి దగ్గర పైన ఉందట, నాకు ఎవరు పోరటండి. హలో శ్రీనివాస్ గారు, బాగా వినిపిస్తుంది. మంచిది. అవును సార్.
Item password matter, item 13 and 14, Ravinder A. Yes, Vijay Prashant.
I'm for record safety. My landfill is having directing is there.
Tomorrow, finally, number of applications so the urgent by workshop team the interim orders they are not going effect from they are not affected by promotion. My client also not getting promotion, but they are not effective promotion since 2017 by workshop this order. You are for unofficial response.
What about the contempt?
Contempt for not implementing the contempt in my interim orders, we file contempt. They are implemented. They file an affidavit. Now once again they are reviewed seniority. You lost my year the year and finalize the petition itself.
Council का respond number 1 from
3 and 4.
3 and 4.
For the respond.
Post 1. 811 finally. Left one, 811. Finally.
Item 45 to 47 R. Prabhakar, Satyanarayana, GP for Social Welfare Services. Item number 45.
Yes.
The petitioner is questioning inaction on the part of the respondents in counting 4 annual grade increments, taking the suspension period is not on duty, my lord. In spite of setting aside the disciplinary proceedings initiated against the petitioner, my lord. The petitioner, while he was working as a hostel welfare officer, he was suspended, my lord. Charges were framed. A common inquiry was conducted against 32 wardens and matters. Inquiry officer appointed by the appellate authority, my lord, in this case. It is against natural justice, my lord. Already we have filed judgments also, my lord.
Who has to support? Who is supposed to appoint? Who is authority?
District collector is the competent authority.
Authority to
disciplinary authority.
Who is appointed in this case?
District collector, commissioner of the social welfare. Already I have filed these judgments, my lord, already, and now I am filing, my lord. Re-inquiry is not sustainable. Division bench delivered, my lord. The item number 45, my lord. The disciplinary proceedings stood abated case, my lord. They have imposed punishments, recovery orders against the petitioner, my lord. Impermissible orders are continuing in this case, my lord. This facts of the case is, my lord, the common inquiry officer appointed by the appellate authority.
Yes.
The inquiry officer conducted the inquiry. Report submitted to the appellate authority, my lord. After examining,
where is the report?
it is already set aside by this imposed punishment, my lord, by the first respondent. My lord, with IA number 1, Lord, kindly filed on 6/3/2023, Lord. First is the punishment, Lord, 10/7/1996, page number 27 to 33, Lord. Running in this, Lord. IA.
Yes.
2023, Lord. First imposed punishment is stand good, Lord. Without cancelling the first inquiry officer's report and imposed punishment, they have initiated fresh inquiry against the petitioner. Again, the second inquiry, he was fully exonerated from all framed charges, Lord. Instead of issuing final orders, the district collector recommended the EO's report sent to the first respondent, government. Government sent to the vigilance commissioner without without examining the inquiry report. They have sent the inquiry report to the vigilance commissioner. The vigilance commissioner report, my lord, at page number 47, my lord, again. He has instructed to defer the total exonerated EO's report, my lord. Second inquiry. Page number 47, my lord. Yes. Vigilance Commissioner report. Idea. I have filed a lot.
He is not served on, maybe it's not available for server. Matter pertaining to 2017.
21430. 21430 2000. This is filed on 6/3/2023.
But it's not in the final.
Already I have started with lot.
I can't serve one more copy. Sir, what about the reason given by the vigilance officer for re-inquiry?
He deferred the total inquiry report, my lord. He sent to the disciplinary authority to defer the EO report and imposed recover the same amount.
In this
First.
case, records are also much more. It deals with the officer, who not accused officer who already expired in the year 2011. Now the wife is before your lordship.
They are affected by this subsequently.
But in the counter, what we said regarding to the case deals with regarding to the abatement of proceedings. Here, the entire inquiry my submission.
Concluded, but only see vigilance officer. I think he has.
And there is an amendment to pension rules, 9(7).
What it says.
Saying that if any loss is caused to the government that can be recovered. So that also to be looked into.
But what is the reason is for reason on what basis the vigilance commissioner didn't agree with the report, inquiry report, and then he has. Just that is there. Why can't serve a copy then take up tomorrow, day after tomorrow, anything?
Not for me, but I need to look at the record.
How much?
1 week.
No,
Because
yesterday
we have 5 benches dealing with service matters. So if I take the days, I
So
should
anyway, we'll post it finally next week. Next week.
next Tuesday.
Next Tuesday.
These are coming for the first time.
No, I think it's already there. 15 level.
Yep.
9th or 10th.
He is asking for the week. 10th is fine. 10th is okay.
One are the same, my lord.
No. 10th, this Friday is okay or next week will be 15, 16. Contempt will be there. 15, 11.
15 or 16.
16, 11 finally. Use, in the meanwhile, you serve copy. Anyway, now 2017, it doesn't make any difference.
Only legal issue, just I go to the record, make my submission.
The request. Post on 16, 11. It also, council petitioner is directed to serve copy of IA 1 of 2023 on the respondent. Three cases.
8 cases.
Sixteen level. Item 48C, Rajshekar Reddy, GP for Social Welfare, Balakrishna Road. Services 5.
Let my name is printed below. GP services 5.
List is directed to in the name of GP services 5. GP for service 5. 5 1.
In case of
see passing spots on passing spots on no one GP for services fine
647.
passing spots.
Yes.
Yes.
May I have it tomorrow?
One you only taken person.
No, the other side question.
You are
Shikari.
business tomorrow. Please respond it.
Lord, in this last occasion, an argument shared at the bench. So the records called for the Lord, I didn't receive the record.
There's no need.
They only say because of the court order, my Lord, he has given the seniority. That needs to be checked.
No, it doesn't say it. There is no order to suspend to the secretary.
No, during the course of arguments, my Lord.
It is not recorded. Docket is
It's not by
not.
the court order.
What records you will?
Actually, my Lord, we are taking a shelter under the court order. Your watchman kindly say parallel
Write up counter.
of the council.
Yes. Yes, good.
G. Mallareddy.
Was first appointed.
Mallareddy is a petitioner. Was first appointed in 2/9/1997 as SGT, while Dayakar was appointed on 24/10/1991 as SGT. This is petitioner was appointed in the year 1997 and unofficial respondent in the year 1991. For Dayakar is senior to G. Mallareddy, and more particularly when G. Mallareddy was under suspension, he was considered as an eligible candidate for promotion in terms of specific and clear orders of APAP. For giving promotion retrospectively to the respondent number 5 on par with his juniors. The claim of Sri Mallareddy repetition is untenable. The copies of the orders. The petitioner Sri Mallareddy has concealed the fact of his suspension and the orders issued thereon and misrepresented the facts to the Honorable Court that his case for promotion to the post of PG Headmaster Grade 2 was ignored. This is not correct. There is no violation.
You want to place on the OA order? Or place?
And prior to that, in also Dayakar Reddy, the respondent was given minor punishment of censure. The Honorable APIT has held follow. So far as a matter relating to promotions is concerned, in any event having regard to the fact a minor punishment was imposed on the petitioner, there was no bar in promoting him to the higher court. Accordingly, we have promoted. The fifth respondent was given promotion on par with his juniors, and his seniority also revised, though petitioner is aware of the revised seniority with suspension. He suppressed his setbacks in the petition.
When you want?
1 week, 16
1611.
I'm appearing with the fifth respondent, madam.
Yes.
So far as the petitioner is a junior to me, basing on the orders of the Honorable Court, madam, page 35 to 41.
I know.
Counter filed by official respondents. OA number 7291 of 2012.
Yes.
Page 35 to 41 minute counter filed by the government.
See now, the GP is taking time for 1 week time for further any doctor need to buy? Any doctor or any?
The order copy filed by the government minute page 35 to 41. Showing minute I was given notional promotion on par with my junior, the cadre of school assistant.
Yes.
And therefore he cannot contain that minute I am junior to him.
The request of GP for services fine. Post on 16.
Item 55C, Sai Reddy, MV Ramaru.
In this also, I request your lordship, my name is the services so that it will be easy.
Please, 55. Please say that. 54. Please say
Earlier.
54. Please, 54. 54. No, that 44, 46% only direction is given. 45 your name is.
48 items.
48 you also say. Even this.
Wait. It's not a leak of import from service.
55 centers.
Right.
Relating to remote from service.
Yes.
The Aquila charts were distributed
on 9/2/2010, that is at page number 11. Page number 11 is the article of charge.
Yes.
You are charged at phase 12. You must start from phase 11. Charge at phase 12.
Yes.
They charge. So A Balasubramanian seeking was sanctioned 8 days CL from so and so date to so and so date. Instead of reporting back for duty on so and so date, he has admitted in Usmania General Hospital on 6/8/2008. As per the advice of the civil assistant surgeon, OZ Hyderabad, he has taken ML. ML means medical leave. Medical leave from so and so date to so and so through AC, Assistant Commandant, SPF, AP High Court, Hyderabad. Instead of reporting the duty on so and so, he has sent application for extension of sick leave from so and so date to so and so, that is in 6/12. Advised by the CAS OGH, Civil Assistant Surgeon, Usmania General Hospital, Hyderabad. Even after completion of his extended medical leave, he has not reported for duty on due date, that is 18/3/2009. Now this is the charge.
Yes.
And became OSL, overstay of leave. OSL means overstay of leave from medical leave, the effect from 18/3/2009. During this his continuous OSL period, he has not informed his whereabouts to his superiors and completed desertion period of 21 days. Subsequently was declared as a deserter with effect from so and so date as per the order 184 of APPM part 1 by letter number so and so dated such. Well, here my first submission is 180 AP Police Manual part 1. AP Police Manual has no application to this department, this Special Protection Force department. This is separate department. This is not part of Home Department.
It has its own rules.
Yes, they are service rules.
This department has separate rules.
Yes, they have service. They have their own service rules. And here this is the dispute matter, governed by the CCA rules. The AP Police Manual has no application to the Special Protection Force Department. Special Protection Force Department is not under the Home Department.
But what about APCS rules, conduct rules?
Yes, APCS, CCA rules, conduct rules, our state and subordinate general rules are applicable to all the departments, including this.
There in charge. Article 1, it is mentioned
Yes,
that
this article of charges was
three of
under
APCS
CCA, under Rule 20 of the CCA. Here, in the charge, because he became OSL from 18/3/2009 and continuously absent for 21 days. He was declared as a deserter under order 184 of Police Manual. But the Police Manual has not applicable to this purpose. I raised this specific contention, but they have admitted that this is not applicable to them. But the charge is, it is very clear. He has OSL from 18/3/2009 onwards. Overstay of leave. But this is neither unauthorized absence.
but having completed, he's taken on more than 6 months leave.
No, that is not that point. Blood initially was applied for the leave on 27/8/2008 on medical grounds. And he admitted in as inpatient in Usmania General Hospital. He was to treatment, and the doctors of Usmania General Hospital advised them, and they themselves have sent the report. Based on their reports, the department has issued sick leave passport. Sick leave, sanctioned sick leave for a particular period, initially for a period of 4 weeks.
After that, again, my lord, he made an application for extension of leave since he was not recovered from ill health. Again, it was sanctioned.
Yes.
Those 194 days is not the unauthorized absence or overstaying. They reported that the 18/3/2009 onwards, he was absent for duties continuously for more than 21 days and declared as a deserter.
Yes.
Under police manual, which is not applicable to this record. Well, the petitioner has submitted his written statement of the explanation on 3/3/2010, denying the charge and stating that he was admitted, he was took treatment, and because of illness, he is extended leave from time to time, and from 18/3 on to 2003 on 18/3/2009 also, he sent 2 letters through registered post. But the assistant commandant, who is the immediate superior officer to the petitioner, has refused. And the postal envelope that was returned and the post with the postal endorsement stating that addressee is refused to receive the same. I filed those covers also, postal covers.
Tell me the facts.
Pardon me?
Tell me the fact. What are the facts?
Yes. Covers, not?
Facts of the case.
Yes, sir.
When he was appointed and counters file.
Counterfeit.
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 The game is few facts.
Yes, but he was appointed as constable. That is CT number 1916 or 1916. That is SPF constable.
Yes.
And while he was working as such,
when was he appointed?
The date was not given. But that is his date of appointment is not relevant to this issue.
Right.
While he was working as SPF constable.
Where was he? Where? You are working where?
Well, at that time he was working at the Tirupati when he was made an application for medical leave. Subsequently, was transferred to Hyderabad after his reinstatement. And at the time of disciplinary action and the removal order is passed, he was in Hyderabad.
Yes.
So the charge memo was issued on 11/8/2011. Just which I have read. That is OSL from 18/9/2009.
Page 11. Page 11.
Page 12. Charge memo. For which I have submitted my written statement of defense. This explanation, page 13 on 3/3/2010, denying the charges and stating all the things.
What was defense taken?
That the defense statement at page 13.
What was the ground?
Ground is not to overstay of the leave. He went on medical leave with the prior sanction of medical sick leave. And on 19/3/2009, he sent an application for extension of medical leave. So that was refused by the assistant commandant and declared him as having refused to receive the extension of medical leave and declared him as a deserter. And the deserter report was sent to the commandant, and the commandant issued the article of charge based on it. Well, may I read it? The defense statement is very lengthy.
Only say about ground. What are the main grounds?
I'll come to Martin. Then thereafter,
Relevant paras, not quite all.
Yes, that's my kind history. Page 14. Page 14, last one.
Yes.
Page 14, paragraph 3. Paragraph 3. I respectfully submit. I will read from paragraph 2. I
I respectful sir, after refusing the postal cover sent by me on 19/3/2009,
Yes.
with my ML extension, medical leave extension, petition, extension petition, and the Xerox copy of MC medical certificate for the reasons best known, the learned AC Assistant Commandant SPF wrote a report to OSL from 18/3/2009 against me, reasons for which are not known, and made me to suffer mentally for no fault of me as OSL from 18/3/2009. I respectfully submit that. On my appearing before the medical officer Usmania General Hospital on so and so date, the medical officer advised me for the treatment and rest for 6 weeks from 4/5/2009 to 26/2009 with endorsement on ML passport dated 6/8/2008. Xerox copy of the medical endorsement of medical officer dated 4/5/2009, and my application was sent to the AC SPF Tirupati by registered letter number so and so dated so and so from HPO Hyderabad. However, this cover was also refused by the AC SPF for the reasons best known. The cover with the postal endorsement addressee refused, hence returned to sender on 11/5/2009 is enclosed in the Annexure 2. I respectfully submit that I did go on OSL from 18/3/2009 as is evident by Annexure 1. I did not absent for duty as I reported for the learned AC SPF. I respectfully said that the MO Usmania General Hospital advised me further treatment and rest with effect from 26/2009 as follows with endorsement in the ML passport. These are the dates.
Only on 22/10/2009 you became.
Yes, 22/10/2000 on 22/10/2009 I have reported for duty.
Yes.
Next page, next paragraph also. I have submitted Xerox copy of the passport dated so and so with the endorsement of MO in Annexure 3 and 4 on so and so dates to the ACA SPF Tirupati by registered post. The postal receipts are enclosed as Annexure 6. I respectfully say that I have taken treatment for acute LBA with asthma, dysphonia with asthma in Usmania General Hospital, Hyderabad, with hospital number so and so dated with effect from 6/8/2008 to 22/10/2009, and submitted Xerox copy of MC given by me by MO on each spell of 6 weeks of 2 months periodically to the ACF SPF Tirupati by registered post. The original medical certificates are enclosed here along with ML passport dated so and so with endorsement of MO Usmania General Hospital, Hyderabad for kind perusal and record. Originals.
Yes.
I saw original ML passport 6/8/2009 with the MO endorsement for extension up to 22/10/2009. Medical certificates dated 19/11/2008, 19/12/2008, 19/1/2009, 19/2/2009, 19/3/2009, and 4/5/2009.
Yes.
And the fit for duty certificate, fitness certificate, dated 22/10/2009. And requested, this is not the neither OSL nor unauthorized options. It is only because of ill health. So exonerate me from the charge. They have not considered it and appointed.
Why the covers were returned or refused? Why the covers were refused?
Covers,
Why the covers were refused by the officer?
yes, I filed along with.
Any particular reason for refusal?
No reason. Last week, kindly see the endorsement, postal endorsement. Even that was not answered, though I specifically raised this ground in my explanation as well as in the repetition. They have not answered this ground in the counter. But I filed IA to 2023 which was allowed. Since this matter was hard attempted by other guys, advisor to file Xerox copies at least. Lord, these are the medical certificates. Page number 7 is sick passport. Sick passport means sick leave, sanction of sick leave.
Yes.
Medical leave passport, page 8. This was endorsed twice on 19 to 2009 and 19/3/2009 twice.
Yes.
That's what got it. Great. Then in page 9. Endorsements, extension of leave 19/12/2008, 5/8/2008, 19/1/2009, 19/11. These are the extension of sick leave by the department itself. Medical certificate issued by the Small General Hospital. Page 9, 10, 11, 12, and 13. 13 also endorsement. Medical leave extension endorsement. These are up to pages 24 more. These are all the medical reports. The assistant commanding refused the registered letters. Last night I filed cover similar Xerox copies.
31, page 31, 33.
Yes, addressee refused. Hence returned to sender on 21/11/2008. This is first one. Second one is addressee refused to receive. Hence refusal. Hence returned to sender 23/2/2009. And the third one is absent on so and so date 23/3/2009 and addressee refusal, hence return to sender 24/3/2009.
Right.
Last addressee refusal, hence return to sender 11/5/2009. Last two covers that is 24/3/2009 and 11/5/2009. This covers the charge. Their allegation is from 18/3/2009 onwards. He is OSL. He became OSL.
21 days.
So, from 19/3/2009, I have sent the application for extension of medical leave, no registered post, which was refused by them. Having refused by extension of medical leave application and issued the charge memo stating that you are OSL from 19/3/2009 onwards.
Right.
This is the charge. Now, when the charge is become OSL from 18/3/2009, and became exhibited lack of integrity, conduct unbecoming of a government servant. This is the charge. This charge is required to be proved in the inquiry based on the admissible evidence, that is depositions of the witnesses and the documentary evidence. Last may kindly see the inquiry conducted, only sole witness was examined. The assistant commandant who refused to receive my leave extension of medical leave extension application through registered post was examined. But naturally, it is a natural tendency that he is supposed to be justify his actions.
What is this? What are the cross exams? Any cross examination done? What is the response?
Cross examination, the cross examination by the inquiry officer.
Yes.
The last look at that is at page 20.
20.
Page 20, last one. Cross-examination by the inquiry officer.
Yes.
Lord, this is the inquiry officer cannot be examined the neither chief examination nor cross-examination by the inquiry officer. This is also prohibited under the law. He is supposed to be acted as a judge. Is not a representing officer like a public prosecutor. But here the inquiry officer himself cross-examine. Question number 1, last one. Why you have obtained medical press directly from hospital without reporting at SPF units while there were orders not to do so?
Yes.
I do not know this. The orders. What are the orders? He do not know. He questioned that what are there were orders not to do so. He did not. That orders are, I do not know. Second question. Why have not reported for duty immediately after receipt of desertion orders? Why have given sick intimation further? I have not reported for duty due to my ill health. Due to ill health.
Yes.
Next, findings of the inquiry. It is clear from the record that charged officer had adopted irregular sick procedure from 5/9/2008 and continued like so till declaration of his desertion with effect from 19/3/2009. Even after declaration of desertion, he had not reported for duty and continued like so till 22/10/2009 by adopting irregular sick procedure. Thus, it is clear that he adopted irregular sick procedure for such long period.
Even desertion, it says that from 5/9/2008.
Yes, but only charge is from 18/5/9/2008. That is from the date of application for extension of medical leave.
Yes.
But charge is only from 19/3. But here this is the important point. The charge is from 19/3/2009 onwards, he become OSF. Charge is that, and he did not integrate the duties and unbecoming of a government servant because of OSF. That's my kind. But whereas the inquiry was not conducted on the charge framed against the petitioner. The charge framed against the petitioner, he became OSF from 19/3/2009 onwards. The questions put by the inquiry officer to the petitioner and findings are not related to the charge. The irregular sick procedure is not the charge. Irregular. So the inquiry officer has not conducted the inquiry on the charge framed against me. And the second point is, the inquiry officer went beyond the scope of inquiry. The scope of the inquiry is to conduct the inquiry into the charge framed against, that is, whether he became OSL or not from 18/3/2009 onwards or not. But there is no report. There is no findings. The irregular sick procedure is not at all a charge. But the Honorable Supreme Court.
Finding is contrary to the charge. Finding of the inquiry officer is contrary to the charge.
Charge. That is, he has no business to do such findings. He has confined to conduct the inquiry into the charges framed against me. He was interested that duty only. But in this regard, on this point, I relied upon his judgment of Honorable Supreme Court, 2006, 5 SCC 88. I have not given more, I will submit more.
One judgment.
One judgment is there, that is an unauthorized, on the ground of unauthorized offense. I have given one judgment, but the judgment I will submit not still. 2006 by SSC 2008. Inquiry officer cannot conduct the inquiry into the allegations with which delinquent officer had not been charged.
Yes.
And another judgment of AP High Court, the AP High Court rules, very same CCA rules, for Telangana AP, only Telangana adopted those rules. So the AP High Court also 2023 2 ALD AP 246. 2023 2 ALD AP 246. These two judgments on this aspect, whether inquiry officer can conduct the inquiry, which is not the charge, the charge memo. The Honorable Supreme Court and the High Court categorically held that inquiry officer cannot conduct the inquiry and against the charge which he was not framed against the delinquent employee, and he went beyond the track. It is the scope of beyond the scope of charge inquiry. Plus, I will. I'm sorry, Lord. I will give these two judgments in.
Yes, sir.
Yes, sir. This is based on these findings. The disciplinary authority has communicated the inquiry report, calling my explanation.
When?
I have submitted my explanation, Lord. That is at page
21. What is 21?
Yes. 3/10/2010.
Yes, 21. Yes, 20.
In this, my final explanation, I have categorically stated all these things. Last my kinds, page 22. Important paragraphs.
Yes.
Paragraph 21, paragraph 3. And I respectfully submit that after availing 8 ACL, I did not report for duty in time because of my ill health. And as per the advice of Civil Assistant Surgeon, Usmania General Hospital, Hyderabad, I was passported to avail 30 days ML by the Assistant Commandant SPF AP High Court, Hyderabad. Due to non-recovery of ill health, I availed 194 days medical leave from 5/9/2008 to 18/3/2009 in 6 spells. These are the sanctioned medical leave. Next, I respectful subject. Availing 194 days medical leave in 6 spells had been informed to the Assistant Commandant SPF PDT office through registered post, and the same was received by the Assistant Commandant office. Due to non-recovery of ill health and as per the advice of the medical officer, Usmania General Hospital, Hyderabad, I have availed another 205 days ML from 19/3/2009 onwards. This is OSL 22/22/10/2009, and the same was informed to the Assistant Commandant through registered post. But those registered letters were returned with the remarks of postal endorsement as refused to accept and returned to sender that resulted my OSL from so and so date from 19/3/2009 to 22/10/2009.
Yes.
I respectfully next page. I respectfully submit that the above said returned registered letters were submitted to the OE officer, inquiry officer, at the time of oral inquiry. These documents are the only evidences to prove that I had informed my whereabouts and my condition to my superiors, but the OE officer has not taken those written registered letters into consideration. Further, I respect submit that the OE officer cross-examined me only on adopting irregular medical leave, but not on the charge framed in the AOC article of charge.
Yes.
So, This was not considered by the disciplinary authority and concluded the disciplinary proceedings, passing final orders, removing, imposing penalty of removal from service. That is at page 23. Last my guide is the removal was this punishment of removal was imposed for on the ground of unauthorized objects. The charge is OSL from 18/3/2009 onwards. Findings of the inquiry officer is adopted irregular sex procedure, and whereas punishment was imposed on the ground of unauthorized objects. Last my guide, page 24. Page 24. This is the page. This starts from page 23 up to paragraph 6. What I have read earlier, the same things. Paragraph 7 last meeting. Paragraph 7, page 24.
Yes.
I have carefully gone through the entire. This is the reasons recorded by the discipline authority while imposing penalty of removal from service. I have carefully gone through the entire PR file, PR punishment role file. More particularly, the inquiry report submitted by the EO who held the charge as proved. What are the EO find charges? What is the charge? What are the findings of the inquiry officer? Now just I have read, brought to your right last time notice. Now he said charge is proved. No inquiry was conducted on this. I do not agree with the plea taken by the charge officer. The plea taken by me is not accepted. This is the reason. As the this is important. Plea taken by the charge officer as the charge officer was on unauthorized option for a long period of 217 days with effect from 19/3/2009 to 22/10/2009 without any intimation to his superiors. The charge is one thing. Inquiry was conducted and findings given by the inquiry officer is a different thing. And penalty was imposed based on another third reason, which are not the part of the charges. This is the charge number 19/3/2009 OSL. I have stated that I sent the extension of medical leave through registered post 4 times, and the assistant commandant was refused and sent the report to the stating that I am became OSL from 19/3/2000 onwards, for which the charge memo was issued. But inquiry findings are different. Inquiry was conducted on other aspects which are not part of the charge.
Yes.
And the reasons given by the disciplinary authority for imposing penalty of removal from service is also different. Then last my time is on this aspect, unauthorized options. On the ground of unauthorized options, even let us presume that, though I am not admitting, but for sake of arguments, because they stated in the issued order for as a reason for imposing penalty of removal from service. I submitted the judgment copies. Honorable Supreme Court judgment. Subject to, this is the 2012 TSHC. I place another judgment. Judgment which was placed before last week will be reported in another judgment, very same judgment. Another judgment, paragraph may be different. Last week kindly.
What are the parties?
Parties not Krishnakant B.
Yes. Yes.
Unauthorized options. What is the unauthorized options? Last my kindly head note. Standard. Options from duty, unauthorized options, absenteeism, willful options, to necessity. appellant unauthorized absence from duty during 3 consecutive periods, 36 days, 32 days, and 234 days. Consequent allegations of failure to maintain devotion to duty and conduct unbecoming of a government servant. Here also these two things are there, devotion to duty and unbecoming of a government servant. Charge. Unbecoming of government servant and dismissed based thereupon. Held for sustaining such allegations, it must be proved that unauthorized absence was willful. If absence is due to compelling circumstances under which it is not possible to report for or perform duty, such absence cannot be held to be willful and employee guilty of misconduct. In the instant case, neither the inquiry officer nor appellate authority found absence of appellant willful, despite his specific defense that he was prevented from attending duty and was not allowed to sign attendance register. Evidence produced by the appellant and substantiate his claim was ignored by the authorities concerned, and on the basis of irrelevant facts and surmises, he was held guilty. Yes. In support of this last kind of relevant paragraphs.
Yeah.
Relevant paragraphs 14 to 20.
Yes.
14. The inquiry officer noticed the aforesaid facts and held that the appellant was unauthorizedly absent between so and so dates and so and three spells. However, while coming to such contention, the authority failed to decide whether such absence amounted to misconduct. The evidence led by the appellant in support of his claim that he was prevented to sign the attendance register and to perform duty, though notice that the inquiry officer on presumption and surmises held the charges proved. But yet, in this case, he was not allowed to perform the duties to sign the attendance register. Here, I was sick. Admittedly, I was sick, and sick leave was granted from 5/9/2018 to 18/3/2009. 5/9/2008 to 18/3/2009. This is not the charge. This is a 194 days in 6 spells. This was sanctioned medical leave. Only the allegation is from 19/3/2000 onwards to 22/10/2009. 227 days. These are the OSL period, according to them. That's my page 16, paragraph 16. Let us go to para 17, para 16, 15, 16 only. Findings of the scope. 17. If the absence is result of compelling circumstances under which it was not possible to report or perform duty, such absence cannot be held to be willful. Absence from duty without any application or prior permission may amount to unauthorized absence, but it does not always mean willful. There may be different eventualities due to which an employee may be abstained from duty, including compelling circumstances beyond his control, like illness, accident, hospitalization, etc. But in such a case, the employee cannot be held guilty of the failure of devotion duty or behavior unbecoming of a government servant. Here is also the petitioner was fell in sick. He was hospitalized. Medical leave was sanctioned for 194 days. So, because of compelled circumstances, he was not absent. That is not willful. Mere absence is not a misconduct. The absence for the duties willfully, that is only the misconduct.
Petitioner has got medical ground on a ground of
medical.
Next.
In this case, it's a medical ground, which is not beyond my. It is not in my hand. It is beyond my control. Paragraph 18 also was. in a departmental proceedings, if allegation of unauthorized absence from duty is made, the disciplinary authority is required to prove that the absence is willful. He may be absent for duty, but that must be a willful, not under any compelled circumstances or medical grounds or other things. Willful. If it is a willful absence, then it is misconduct. In the present case, the inquiry officer on appreciation of evidence, though held that the appellant was unauthorized absent from duty, but failed to hold that the absence was willful. Disciplinary authority has also, the appellate authority, failed to appreciate the same and wrongly held the appellant guilty. This paragraph 20 is important. The question relating to jurisdiction of the court in judicial review in departmental proceedings fell for consideration before this court in M.V. Vizrani versus, which I report in paragraph 25 in the judgment. It is true that the jurisdiction of the court in judicial review is limited. Disciplinary proceedings, however, being quasi-criminal in nature, there should be some evidence to prove the charge. Although the charges in a departmental proceedings are not required to be proved like a criminal trial beyond all reasonable doubt, but we cannot lose sight of the fact that the inquiry officer performs a quasi-judicial function who, upon analyzing the documents, must arrive at a conclusion that there had been a preponderance of probability to prove the charges on the basis of the material on record. While doing so, he cannot take into consideration any irrelevant facts. That he cannot refuse to consider the relevant facts. He cannot shift the burden of proof. He cannot reject the relevant testimony of the witnesses only on the basis of premises and conjecture. He cannot inquire into the allegations with which the delinquent officer had not been charged with. Here is also findings of the inquiry officer is on irregular adopting irregular sick procedure. That is not a charge. The charge was not framed against the petitioner.
Yes.
So even assuming that petition was authorized, this is not unauthorized willful absence. It's not a misconduct. In support of this ground, one more fact, last mechanism. Alleged unauthorized absence for 217 days.
Yes.
For unauthorized absence of 217 days, he was imposed a penalty of removal from service. Last mechanism, which is 268, page 33 of petition.
Yes. Yes.
Last paragraph 4th last mechanism. This is only paragraph is announced.
Yes.
Paragraph 4, page 33.
Government hereby
directed that in all cases of unauthorized absence to duty for continuous period exceeding 1 year, penalty of removal from service will be imposed on the government employee for duly following the procedure laid down in the APCCA rules 19. Here 217 days is not
less than 1 year.
Less than 1 year. Even against this include punishment penalty of removal from service. But there is a statute rule in rule 33 of CCA rules. I availed it. I filed an appeal before the appellate authority. Filed appeal.
Appeal filed before whom?
Before a Deputy Inspector General Special Protection Force. That is at page number 25. Deputy Inspector General Special Protection Force, Buddha Bhavan, Secunderabad, Hyderabad. In this appeal, I raised all these grounds now which I have argued.
Yes.
But then appellate authority order is what order is passed last time it page.
You filed that copy, appeal file?
Yes, I'll come to just I will conclude the blood within 2 minutes. Only this is the last part.
Yes.
Page 31 is the rejection of appeal by the appellate authority.
Yes.
Last paragraph here. I have gone through the appeal petition, service purpose of CA so and so, and EO's report carefully. And I do not agree with the plea taken by the appellant as he was unauthorizedly absent for his legitimate duties for a long period of 217 days.
Yes.
Well, this is nothing but non-application of mind on the part of the appellate authority along with the disciplinary authority. But this is the unauthorized absence is not the charge. Leave another 17 days with the 93/2009 to 200 days. Then against this I filed the revision also before the Director General Special Protection Force in the law. But the page 32 is the rejection of my remote. Rejection of revision dated 16/4/2012.
Yes.
Page 32.
Yes.
I have gone through the revision petition of the individual and the disciplinary case instituted against him for his prolonged period of overstay from leave carefully. But the original punishment order, appellate authority order is based on unauthorized options. But here he said overstay, prolonged period of overstay from leave carefully. He has contended that he has submitted application for extension of medical leave from time to time and was forced to under treatment and bed rest as per the advice of the treating doctors until 21/10/2009. He also states that standing acts of the police manual have no application to SPF personnel as regards desertion and that no sick procedure is stipulated in the rules and that punishment is disposed to the charge. It is not understood why the individual who is supposedly so well versed with the rules was unaware of the prescribed procedure for extension of leave on medical grounds where he is not hospitalized, having put in 12 years of service. He was hospitalized. This is a factually error. But he admitted that there is no answer from them. That order 184 of police manual has no application to this. This is the answer given by the regional authority.
Yes.
This is the only thing. On these grounds, they appeal and the revision was rejected. But it is the duty of the appellate authority and regional authority as per rule 37 of the CCA rules. How to consider the appeal and how to consider the revision.
Yes.
May I read rule 37?
Yes. Yes.
37-1 against the appeal against the suspension order. From 2 against the punishment. Penalties. Rule 37, sub rule 2. In case of an appeal against an order imposing any of the penalties specified in Rule 9 or Rule 10, or enhancing any penalty imposed under the rules, the appellate authority shall consider, they have no option, but they have to consider, it is mandatory on their part, whether the procedure laid down in these rules has been complied with, and if not, whether such non-compliance has resulted in the violation of provisions of Constitution of India or in failure of the justice. But here, the charge is overstayed. Inquiry conducted on different aspects. Findings on irregular procedure. The disciplinary procedure, final orders concluding disciplinary proceedings by the disciplinary authority imposing the punishment on unauthorized grounds. But this, it is required to be considered by the appellate authority whether what is the charge and what are the inquiry conducted, whether inquiry was conducted on the charge claimed against the delinquent employee, and whether there is any findings, and whether findings of the inquiry officer is relevant to the charge. And the reason given by the disciplinary authority for imposing penalty is also relevant to the charge. Nothing. This is also the disciplinary authority, appellate authority, as well as the revision authority. All the authorities have miserably failed to consider the rules.
Yes.
So the impugned order is liable to be set aside, and the repetition is liable to be allowed.
Yes.
Actually, the petitioner, he availed the leave of 8 days only, Lordship. And thereafter he sought for extension 5 times. And total it was extended from 5/10/2008 to 18/3/2009. 5 times it was extended.
5/10
5/10/2008 to 18/3/2009. And he was supposed to report back on duty on 18/3/2009. And his period of 21 days expires on 8/4/2009. Within 21 days, he was supposed to report back, but there was neither any intimation from him, nor did he report. He was declared as a deserter on 18/5/2009 with effect from 19/3/2009.
He has sent further extension of medical leave through reached report. Those were not issued by the
Lordship,
officer.
in
He
the
refused to take that.
Yes, Lordship, in the counter we have replied for that, Lordship.
What is the answer?
Lordships may kindly see page number 3, Lordships of the counters.
Yes.
Initially, the order of desertion was communicated to him, Lordships. Thereafter, Lordships, through registered post, the applicant sent the letter requesting for the extension of medical leave, and the same was received on 2/9/2009.
Which page? Which page?
Lordships, I am reading from page number 4, your Lordship. Page number 4, panel number 4. To start the middle portion, your Lordships.
Yes.
Thereafter, the applicant sent another letter requesting extension of medical leave, and the same was received on 2/9/2009 by the Office of Assistant Commandant (TTD), And in response to this said letter, he was informed by stating that he was already declared as deserter and the assistant commandant is not competent to consider his request for extension of medical leave and advised him to report before the commandant RZSPF if he was interested to join, upon which the applicant was personally reported before SPF headquarters, and as such he was sent to Commandant RZSPF and he endorsed with his representation as taken him on duty with effect from 22/10/2009 and sent him to his parent unit before ACSPF TPT, and as such he reported for duty before Assistant Commandant on 23/10/2009. Thereafter,
What was the, just read that to, when you are reading that thereafter the applicant sent another letter requesting extension medical leave and the same was issued by 2/9/2009 by the Office of Assistant Commandant. And response to said letter, he was informed by stating how it was informed. Any communication letter?
yes, the beforehand itself, Your Lordship.
Because the other letters say that was those letters were written.
Letters which were refused to receive by them is prior to 29. Those letters from between March to September. This is from September on.
In which ways, Your Lordship, the assistant commander is not, the commandant is not the authority to extend the medical.
Why did he refuse to take the cover?
Lordship,
It was
it was
refused.
written
How can he refuse?
Lordship, it is written in the before line, Your Lordship.
Yes.
In the line before the thereafter. I may read, the said order was communicated to the applicant through registered post while so and so, but the same was written because of insufficient address. The order of desertion was reported, was given, Lordship, to the applicant also.
Have you told those documents? Here are those documents.
Yes, the desertion order is communicated.
Here is it. Have you received? Has Krishna received?
2009, page 4.
Then he says, 160 says that
The said order was communicated to the applicant through registered post number dated 26/2009. The same was written because of insufficient address. The desertion order sent to the petitioner to the incorrect address that was written. But that is not the my
no,
condition.
I am asking whether even for this also is there any proof of sending note these?
The desertion order is at page number 9 of the deputy order.
But even for this also, even any document or proof is there that the desertion order was sent to the petitioner and then it was returned unserved for insufficient address. You have not placed any record.
We have copy marked to the applicant.
Which one you read?
Lordship, page number 9 is the desertion order of the deputy order.
But my situation is whether the desertion order is served or not, that is irrelevant to here. Because they have no authority to issue desertion order invoking the order 184 of AP Police Manual.
That you are saying that is not applicable.
Yes, that is the way they are communicating.
No, but you also want to verify whether there was sent or solely just they are making any.
Already I sent they are admitted that I sent the registered posts after 18/3/2009 for extension of medical leave.
Yes.
Whether I send the extension of medical leave applications or not, the issue.
Yes. What else?
Moreover, Lordship, no reasons given by the applicant, Lordship, besides the medical certificate.
What
and
more?
in the revision order passed by the.
What more you want to get the government hospital, the medical record is there, the duty officer, medical officer is given endorsed on this. What more you require? Even if it's at least we can understand that it's given by some private doctor. It's a government OD, Usman General Hospital, doctor, duty doctor is given there.
Lordship, for a moment, kindly see page number 11 of my complaint.
Yes.
Page number 11, paragraph number 15 here.
Yes.
It is submitted that as pointed out by the revisional authority in his order 16/4/2012, the applicant was unaware of the prescribed procedure for extension of leave on medical grounds when he is not hospitalized, having put in 12 years of service in SPF. Further, he has erred in including medical documents in respect of his daughter's illness, which pertains to a different period and is irrelevant to his period of overstay. It is not understood why he could not press his claim of illness with such documents like medical prescription and diagnostic report for such prolonged period of illness. What the revisional authority has observed is that the medical certificates which he has produced are fake, are forged ones. And
Any action is taken against him for producing forged documents? Any action is taken against him for producing forged documents? Or have you inquired the medical officer there, Usmania General Hospital?
yes, hello. Yes, hello.
That in fact that is also not there in any proceeding. Nothing is there that these documents which is produced are in fact forged one or fabricated. That is not the
That
case.
is not at all charged.
Not nothing
There
is
is
there.
no such allegation. Lord, I filed the medical certificates and the documents, Lord, that pertains to petitioner, not his daughter. Right? Though his daughter was also suffered during the same period with cancer. That is different aspect, not on that point. The later, the regional authorities also given the reason that adopted is a irregular sick procedure. That is not the charge. My contents is that is not the charge.
Moreover, according to the procedure, the applicant is not supposed to approach the medical officer directly. He has to go through a proper channel. But the applicant herein chose to approach the medical officer directly and obtain the medical certificate.
Yes.
It is there in my counter affidavit.
That is.
Apart from the medical leave, Your Lordship, it is the question of unauthorized absence of 217 days.
What is the proper procedure? How he has to approach doctor?
Lordships may kindly see page number 8, paragraph number 8 also.
His number?
8, Your Lordship.
Yes.
Of my count. And number 7.
Yes.
It is submitted that in reply to so the applicant was already declared as deserter and the assistant commandant is not competent to consider a request for extension of medical leave. The question of considering this request for extension of his further medical leave does not arise. And so on.
Right. Any further question?
Stating that the assistant commandant is not competent to extend the prolonged medical leave, the question of refusing or consideration does not arise, and answers the averments that the assistant commandant deliberately sent the reports to the higher authorities is false and baseless. As per the facts stated in it is clearly established that the OSN of the applicant, hence there are no malified intentions on the part of it.
Right. Question?
Procedure, Your Lordships, wherein
Where is
the
it?
applicant directly approached the
Where is
medical officer wherein he is not supposed to. It is extracted in the counter also.
Where? Which page, which para?
the procedure was
What is the procedure? How we have to upload the medical officer after?
But the procedure is, though it is not a part of charge, it is not delivery, but just last possibility. When the employee is admitted in the hospital or is supposed to go to the hospital to take treatment, he make an application to the immediate superior officer and obtain sick passport. That is leave application. Here, the petitioner initially obtained sick passport. And that was time to time extended for period of 4 weeks and 6 weeks, 5 times, like for 194 days. Yeah. Adopting irregular sick procedure, unauthorized option is not part of the charge. That is, no inquiry was conducted on this aspect.
Lordships may kindly see page number 7, Your Lordship. Page number 7 of my counter in the meeting, exactly in the middle.
Yes.
After completion of medical leave, the applicant was due to report on 5/9/2008 along with the medical fitness certificate, but he did not do so. And on the other hand, he directly approached the RMO OGH Hyderabad on the pretext that he was not fully recovered and informed that the RMO advised him for 30 days medical leave and requested for medical leave from 6/9/2008 to 5/10/2008. In this connection, the irregular medical leave intimation was submitted to the commandant so-and-so by 15/9/2008. From there on, he adopted irregular medical leaves from so-and-so. In the period where he was granted medical leave, that is also not through proper challenges. Channel is what we are considering.
What about this page 9 para 11? The counter, they say that the applicant did not choose to cross-examine assistant commandant. Counter page 9 para 11,
Yes.
last 6 lines.
Lord, my contents is he was not allowed to cross-examine. Not allowed to cross-examine. The inquiry officer was not allowed to cross-examine the assistant commandant who refused to receive my digital letters. I took this time.
Where did you say about this?
That's my kind. See page 5 of my report. Page 5. That is paragraph G, starts from page 4, bottom. Page 5, second line. The inquiry officer also not allowed the applicant to cross-examine. Detailed reasons were given from page paragraph G, that is at page 4.
Right. Right.
Last line.
Which one?
Para number 11, Lordship. Last line. Consider
Yes.
the applicant did not choose to cross-examine the assistant commandant SPS, even though sufficient opportunity was given to him. And on the other hand, in cross-examination of EO to question number 1, that way the applicant has obtained medical rest directly from the hospital without reporting at SPF units where there were orders to not.
That's also.
This is contrary to their own arguments in the counter itself.
Applicant replied it as a
The counter they themselves apply passport illegally for period of.
That time. Result.
Item 56.
You can also file chronology event something specific. Next.
Item 56, yes, Satyanarayana GP for Panchayat Raj R. Chandrasekhar Reddy services to.
Yes. Ready? 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 Fine.
The database termination, they indicated the conspicuous Yoga rubbish that was suspended at the tribunal. The petition in service. If they are trying to contest where the petition is liable to the
Counter is fine.
they filed a counter.
Counter also fine. Also fine reply. We can get ready. Supply copies with them.
Occasions we supplied.
Every day, every time in GP change, you need to supply copy. Yes.
I also find a reply.
Item 57, B. Narayan Reddy, GP for irrigation service.
The petitioner is seeking regularization on the basis of parity with other people.
Who is the respondent? Who is appealing for response?
Three is printed.
Irrigation.
Irrigation.
That is 2 years. That is the 3 years.
Who sells it?
That is the 2 years.
In fact, about an order of this honorable court.
If it appears as last date application that is covered by writ appeal.
Yes, madam.
24 of 2014.
He is working in the education department, roads and building department.
RMP department.
Service is 2 years, 3 year elections. They requested next week.
You are applying for 3?
Yes, election. They have informed concern. GP have informed to take that.
Who is GP?
Promise of just 2 years.
Morning you was there.
Yes, yes. Just now he was background reaching before 3 years. 27. Asian pension election period. Just now he informed to take next week.
Yeah, are you placed that order? Writ appeal order?
The last occasion I had given a copy, but remember, this is the order of the single judge and then it's been affirmed.
Order copy.
Just
Is there on record?
Single judge order in petition number 7141 of 2009. Which came in appeal before this honorable court in a writ appeal to 24 of 2014.
Yes, yes.
Identical case. The person was working as an economist in R&B. They have not been regularized by giving the benefit of BOMS number 143. This court said that since this benefit has been given to one Mr. Salanand, it has to be given to everybody.
Yeah.
In fact, a peculiar counter affidavit has been filed saying that the services of the petitioner are very well needed, and he has good experience in executing, look after the R&B good works and maintenance of the R&B.
He's supporting your case.
Yes, sir. The counter affidavit which has been filed in the rate petition, this is supporting my whole case. The only reason on which they deny me this benefit is that I have been removed from service and later I have been appointed back on the direction of this honorable court. This honorable court has held that my removal from service is bad in law and therefore asked them to reinstate me into service. They've also directed them to pay back wages. I have been reinstated into service. I have been paid back wages. I have been working for the past 28 years in this. 30 years now. Today, I think it's joined in the year 1991.
30 years. When you want.
Next week, Your Worship, my reading the name of irrigation. The name of services 1 and 3.
3 already there. Only.
Yes, 3 is already there. The name of services 1.
Fourth respondent finance is a party, Your Worship. Wherein
You are student. Then who is there for finance?
Finance services 1. They are
You not find counter. What do you see? It's already, you say that it's already covered by prison bench order.
Yes, NMR Millard is not considering this GYMS number 143. Section order fast Millard Worship and
Copy of the rejection order is at page number 8 of the OA application.
Counter of Millard is only stated that Millard is not applicable to the GYMS number 143.
Only one ground is taken. What is here? They say that the GOM is 1% doesn't apply to the question. That's only ground which is.
That's their contention, which has been answered to the negative by virtue of this honorable court judgment in writ appeal. The single judge's order and the writ appeal.
The single judge order Millard only for the earlier Millard is industrial tribunal orders passed Millard is without giving any notice Millard issue the termination orders. Basing on the termination order challenging Millard set aside the termination order, and the termination orders challenged by the honorable court. That orders Millard is set aside only for the 50% of the wages was given me.
May not be correct.
So you have
given a copy of the
copy of order.
This petition order in 7 months from 2009, an order passed by Justice KG Shankar. I'll also have a look at the first writ petition order.
Sir, we gone through the judgments next week.
Paragraph number 4.
Friday.
What may happen Tuesday, Friday, Thursday, Friday.
Also, next day.
Pendency, my lord.
15, 11. 14 after 15, 11. The DP for services. What?
Item 58 names Srikanth GP for transport.
You have to make it.
EFR,
Hearing for education consultation.
CM. What about response?
GP for transport.
Working.
Next week,
Also handicap.
How will they exchange? What do you both have not copied? How will get your backup files? Oh, 16/11. It's not 2 weeks. What? 22/11. Post and 22/11 with the request of Councillor Krishna as well as GP for services. This is directed to
Item 59 here, Prabhakar, GP Virtual Education Services 1.
The case of the article 30. And yes, perhaps it is there. I have to take instructions perhaps whether what's happened in the internal agreement.
the surveillance are not that also class surveillance. What is it?
Yes, madam. The petitioners were selected and appointed as a secondary grade teachers and physically handicapped person in DSC 2008, and they were appointed. And after their probation was declared, and thereafter, my lords, on the allegation that they produced a fake physically handicapped certificate, they were issued a show cause notice. Challenging the show cause notice, they filed OA, wherein the show cause notice was suspended. Subsequently, my lords, they directed the petition not to attend the duties. And that suspension case is also pending as of now. That is OA 4714 of 2013.
Suspension is only interim order.
Suspension is only interim order.
Where is that? Then both are
That is OA number 4714 of 2013, my lords. Then we have command to the writ petition. I don't know the.
Yes, then both connected.
Certain.
What is the ground for them to issue this not to attend duties? One ground?
They did not say anything. They just asked us not to. Oral direction.
Oral direction.
No. And the moreover, my lord, the suspension is staring at them. Passed in OA number 4714 of 2013. As per this of OA, my lord, that order is still pending as on that date.
You did not file contempt?
But my lord, subsequently what happened? I have to take this session.
Counter order is
Yes, counter is fine.
the request of council for Krishna. Question 2311.
Obligation.
Krishna is inform the court with the latest status of the issue. I will make the latest status.
60C Sai Reddy, GP for Services 4.
Next week.
Counter file?
Counter is fine. Counter is fine. By waiting to absorption of the expired Hyderabad Army employees, unpaid employees, and amalgamation of organ company with the state government employees and state government departments and in the equivalent departments, in the equivalent categories. And there was technical worker. It was drawing scale of 980 by
Voltas, that's only Voltas. Just will fall into Voltas.
Counter is fine.
The request not to speak, the request of Krishna.
Item 61, Sai
24.
Reddy, GP for Home.
2411.
Yes.
Is the same?
Yes. This is the what is concept, but the punishment of stoppage of 2 increment, stoppage of
reduction of time scale by 2 stages with cumulative effect was imposed. The allegation that he was involved in a criminal case in crime number 18/2002 for the offences under section 420, 493 of IPC of Fourth Town PS Nizamabad. The charge memo at page 14, from page 13, page 14 is
I'm handicapped with the bundle watches in this matter. The watches may kindly post next.
Why every second, third case you don't have?
The case is very simple. The charge is a charge as my page 14. Allegation is he was involved in the crime number 18/2002 for the offences under section so and so.
Yes.
But after filing the charge sheet by the police, that the criminal case was filed challenge report is under section 482 of CRPC for quashing the criminal case. The criminal case was quashed by this honorable court.
Yes.
So, very question of after passing the criminal case, both criminal proceedings, the question of involvement in the criminal case does not arise.
Departmental inquiry you can conduct. The department inquiry was conducted.
That's why first point. The second point is whether the department is have a jurisdiction, whether the petitioner is involved in a criminal case or not. It is the only jurisdiction of concerned criminal court, not is the department. Whether he was committed that offence or not, the department cannot decide it. It is only for the court. This honorable High Court passed that proceedings. After conducting the inquiry, submission of inquiry report, after lapse of 5 years from the date of receipt of the inquiry report, the disciplinary authority concluded the disciplinary proceedings, awarding major punishment. The inquiry officer findings are not relating to the charge. May submit one judgment in the honorable court. Whether the department can proceed with the inquiry when the charge is involvement in a criminal case. Second statement, the charge framed showing involvement of the petitioner in a criminal case is of a kind of charge to which petitioner can neither submit nor resist. No person can be compelled to criminal incriminate himself in any crime. Hence, no employee can be forced to admit any such charge. Disciplinary authority cannot conduct inquiry into involvement of employee in the alleged crime or otherwise. The task has been specifically entrusted to a competent sessions court. There is no way disciplinary authority can announce opinion on one way or other on such charge. Therefore, framing any such charge in absolute redundant exercise, and it is not way warranted.
No way warranted. No way warranted.
This is paragraph 6 and paragraph.
Facts in this? Same facts or different facts? What are the facts?
Facts, the law is whether involvement in the criminal case. Involvement in the criminal case, how the department, whether he was committed an offence or not, and how the department can decide it. It is for the court. The crime was passed by the honorable High Court.
Paragraph 6. Paragraph 6.
Paragraph 6 and 7. Paragraph 6 last one. This is a kind of charge where the petitioner can neither submit nor resist as it as a present right. Above all, no person can be compelled to incriminate himself in any crime. Hence, no employee can be forced to admit any such charge. For instance, if an employee denies his involvement in a criminal case, there is nothing that the disciplinary authority can conduct an inquiry in that regard thereafter. has no power and authority of forming an opinion as to the true involvement of the employee in the alleged crime. The task has been specifically entrusted to a competent sessions court, which can form an opinion after collecting all necessary and relevant evidence. It is for the competent criminal court to pronounce the opinion as to the involvement or the lack of it on the part of the particular person in a crime. Therefore, there is no way a disciplinary authority like the depot manager can pronounce an opinion one way or other on the above quoted charge. There are two charges. In one charge, the involvement, that charge was passed. This particular case, that criminal case was also passed by this Honorable High Court.
Where is that order?
Yes, start from page 17. Point number 1, page 19. This was also framed at page paragraph 3. That points that arises for determination in this petition are whether the proceedings in CC number so and so on the file of the additional judicial magistrate of first class Islamabad against the petitioner accused are liable to discharge. As seen from the section 198 of CRPC, there is a bar for the magistrate to take cognizance of the offence and a police report in respect of offences falling under chapter 20 of the Indian Penal Code. Section 493 IPC falls under chapter 20 of the Indian Penal Code. Therefore, I find considerable force in the contents of the learned counsel appearing for the petitioner accused in respect of offence punishable under section 493. The other allegation is that petitioner accused induced the de facto complaint to have a sexual intercourse, promising that he would marry her, and later he did not marry her and thus cheated the de facto complaint. But admittedly, the de facto complaint is a married woman having child and she is not a minor. The learned counsel for the petitioner contended that even as per the availments of the complaint, the petitioner of the accused never refused to marry her and that he only postponed the marriage and he is still prepared to marry the de facto complaint. Hence, I find considerable force in the contention of the learned counsel for the petitioner that there is no prima facie material in support of allegations of the cheating. Hence, I am of the considered view that this is a fit case to quash the proceedings before this trial court against the petitioner accused. Thus, the point is favored, found favored in favor of the petitioner, and the petitioner is allowed.
Come to page 22. Page 22.
Page 22.
Memorandum.
This is the departmental inquiry.
They say that is proved. Voting charge and
Yes, this is the department. My contention is the department has no jurisdiction to conduct the inquiry into the charge, that is involvement in the criminal case. Like it is the subject matter of criminal court. And in this particular case, that crime was also quashed. Where is the question of proving the charge, establishing the involvement of the petitioner in the criminal case?
What are further steps? What are further steps taken on this?
No, this is the last mechanism, article of charge, page 23. Only only single charge, gross misconduct, page 23. Article of charge, that's got it. Gross misconduct involved in crime number so and so, for the offences under section so and so, PS Nizamabad. Charge officer is working as ARPC, though the letter number so and so Nizamabad informed that on the complaint of the Srimati Vijaya Home Guard number so and so was registered at Town 4 PS Nizamabad against Sri J. Suresh Babu, ARPC Force Center of ER Headquarters Nizamabad. And investigation into. But investigation done and the charge sheet is filed in this criminal case. After filing the charge sheet, that case was numbered as CC 920. That CC was challenged before this honorable court, and this honorable court was quashed.
But
then what is the material available to and what is the competence of the inquiry officer
sanctity of this? You want to say what is sanctity of this proceeding?
Yes, this the inquiry cannot be conducted. Moreover, the inquiry officer findings are the inquiry officer went to beyond the scope of inquiry and gave a finding that is at page number last my kindly page 34.
Yes.
Yes. Inquiry report start from page 23.
Last 34 conclusion is it finding?
Yes, last findings. Page 33, paragraph 14. For the evidence available and the defense taken by the delinquent, whether the following charge mentioned in Annexure 1 and 2 were proved or not, beyond a reasonable doubt, have to be analyzed. Involvement of the delinquent in criminal case by crime number so and so of 420 493 IPC registered at PS Town 4th Nizamabad. The misconduct exhibited by the delinquent who was having illicit intimacy with married women and sexually exploited her by making her to believe that he would marry her. But this point number 2. The misconduct exhibited by the delinquent who was having illicit. Where is this charge? How the inquiry officer framed this charge?
New charge.
Only the charge is involvement in the criminal case. That is last my kindly see page. Charge. Page 14.
What about this? Page 30. Page 30.
Suresh Babu ARPC 472 AR Headquarters Nizamabad has involved in crime number so and so under section under for the offences so and so of Town 4th PS Nizamabad. This is charge. One the inquiry officer went beyond the track, beyond the scope of inquiry. He framed this. Next number. The involvement of the delinquent in the criminal case was already established as per the detailed report submitted by the SI Town 4th Nizamabad. This fact was deposed by the SI Town 4th Nizamabad in his state.
What about conduct of the then prisoner? What is the conduct of the prisoner in this? But only you are saying that except charge, beyond the charge they can't move. That's only your point. The charge in fact is already acquitted, therefore nothing remains in it.
And the department has no power. That is purely private offence. This is any offence relating to the official duties of the employee, then the department can proceed with the department inquiry simultaneously. Here this private offence between the so and so woman promising her to marry is purely private offence. This is nothing to do with the official duties of the petitioner. If the crime is relating to and connected with the official duties, then the department has a jurisdiction to conduct the inquiry.
Just handle notice. And the applicant is involved in the Moral turpitude. Yes, Lord. There is no bar asset that only it confines to the criminal code.
The only problem is that in the charge that what is framed, so only the charge is framed that he is involved in a crime which is registered under 490, 490. And according to petitioner, that the crime, in fact, the charge sheet is filed and the same was passed by the Honorable High Court. So we say that nothing remains in charge, only one charge is framed, the charge is in fact now clear. According to him, it's a different aspect. The department cannot go into this and cannot conduct further inquiry. Whatever the inquiry conducted by the department and proceedings for further proceedings, in fact, say are not legally valid. That's what he says.
Counter is also not filed in next week.
Counter is there.
I'm sorry, but actually I don't have the so
Without bundle, then your counter is there. Hold on.
Lordships may suppose in next week lordship I will say.
Twenty-two 11. Yes.
Yes.
Item 67, that sponsor is not there. Because
Give your home.
But 2 weeks lordship.
2211. Stuff. It will request for GP for services. Secure home.
$72 may not have it's last almost 6 months, maybe taken up as the mother who
No, to the wait, will come. It will continue.
Hearts on my part to stay right from morning to evening. I'm sorry, but I should not say this, but I'm expressing the facts.
Let us see. Let's see. Let's see tomorrow. Let us see.
Item 62, the next item. Tomorrow will continue.
It will continue. Senior counsel, yes.
No, 92. Tomorrow.
It will continue.
No, item number 73 now.
Yes.
It posted at 2:30 p.m. tomorrow.
No 2:30. Just wait for some time. 2:30 if you start, then every case will 2:30. We continue. We'll try to verify. It must be there.
Right.
Massage. Okay.